record and record. And making you the host, Tricia. All right, and then you let the panelists in right now. You have the ability to do that there, Tricia?
Yes.
Should say at the top, let them in.
Oh, sorry, hold on. Oh, broadcast, yes.
There you go.
Okay.
And I will promote Senator Carson, and you are good to go.
And I'm the first one to speak, am I?
It's all you.
Hello, Senator French.
Good morning.
Senator Hanisco, if you want to kick us off,
We're ready?
Yes.
we're ready.
Welcome. I am Senator Martha Hennessy from Senate District 5. And today we will be hearing HB 1162 and its amendment 2020-1324, followed by executive sessions. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of the Senate Judiciary, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic measures. We are utilizing Zoom software for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We're providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate, all one word, at leg.state.newhampshire.us. That's remotesenate, all one word, at leg.state.newhampshire.us. Or you can call 603-271-3043. 603-271-3043. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken during the meeting shall be done by roll call vote. Finally, let's start the meeting by taking a roll call of attendance. When each member states their presence, please also state where you are and if anyone else is in the room with you during this time, which is required under the right to know law. Are you calling the roll?
You are, Senator.
You are, sorry. Thank you.
So I would like to call the roll at this time. Do we have Senator Chandley? I think we have to unmute.
Sorry. This is Shannon Chandley. I am at home in Amherst and I am alone in the room.
Senator LeVake.
Good morning. I am at home alone in Brookline, and I'm alone in the room.
Senator Carson.
Good morning. This is Senator Carson. I am alone in my home in Londonderry.
And Senator French.
And this is Senator French. I'm in the glorious town of Webster, in my home, in the room, alone.
And as I said, I am Senator Hennessy. I am at home in Hanover, New Hampshire, alone in my room. And what I'd like to do is to start with a moment of silence. And after I read this little statement, we will have a 10-second silence. If I had it right in front of me, that would be perfect. Thank you. I would like to ask that we have a moment of silence to keep in mind what has happened over the past week or two, including the death of George Floyd and those who are working hard to end race-based violence in this country and around the world. Thank you. Thank you. I would like to go over the rules and procedures for this meeting, which I will read. I'd like to thank everyone who's participating, not only on this Zoom call, but also those who are listening. We're going to have many speakers today, and they, as is typical of Judiciary, and there I expect many of the speakers will have passionate views on all sides. We have a fabulous staff that will be calling on individuals who have signed up. If you did not sign up, you can do so on the General Court webpage or by raising your hand virtually. If you are calling in, you can raise your hand by pressing *9. If you are having any problems, please feel free to contact our staff again at remotesenate@leg.state.newhampshire.us. To hear from anyone, it is our duty that you will need we want to hear from everyone who wants to speak, and therefore we are going to limit everyone's testimony, as we have in the past, to 3 minutes. If you have written testimony, please submit it, and our legislative aide is happy to make copies of written testimony for the whole committee. We also accept written materials after this hearing. It's our duty to hear from every single person who wishes to speak today. One exception to the 3-minute rule is the prime sponsor, who is the first person to speak on a bill. I will ask the prime sponsor to be respectful of other speakers and also try to limit his or her testimony. So I'm going to give a few quick tips, because this is a new format, something that many of us are not accustomed to, for some of the best practices while we are in this committee meeting. In order to present effective testimony in this setting, please don't repeat what has been said by somebody else. Try to summarize the key points of your testimony and try to make the testimony unique by telling it from your perspective. Some of the most powerful, memorable testimony is brief and uniquely personal to you. In this case, I will not be the one with a timer telling you when 3 minutes is up, but one of the aides or one of our staff will say so. So I would like to, at this time, recognize the prime sponsor of.
Senator Hennessy, just really quickly, so sorry to interrupt. I think for the first bill, we're not going to limit for the 3 minutes because we don't have too many speakers, so.
Good news, thank you very much. I'm going to open the hearing on House Bill 1162. And do we know whether Representative Butler is here?
I'm looking right now. I do not see him on the list. Representative Butler, if you are calling in, could you please virtually raise your hand by dialing *9? I do not see a hand. Senator Hennessy.
Okay, so some of us had trouble getting into this meeting this morning with some technical issues. So what I would recommend is that Senator Chandley, would you be willing to introduce this bill?
Certainly, for the purposes of this discussion, my name is Shannon Chandley. I represent Senate District 11, the towns of Amherst, Milford, Merrimack, and Wilton. And I would like to introduce to the committee for consideration HB 1162. Thank you.
Okay. Senator, we have first would be Sue Chang, and I do not see that speaker either. If Sue Chang is on the phone, could you please dial *9 to raise your hand and I will call on you. But until then, we'll go to the next speaker, which would be Santosh Salvi. Right there. Okay, you should be able to speak, Santosh Salvi. You need,
You need to unmute yourself.
Will do that.
there you go.
Good morning, everybody. I'm used to Zoom, so I'm okay with that.
Okay.
My question to everybody is, I'm a landlord in New Hampshire and Nashua and Manchester. We face a lot of issues right now because we have a situation where we evicted 2 or 3 tenants in the beginning of March for the non-payment of rent for almost 2 months. I did that, and I did not get the order because of the government rule, that governor rule that we cannot evict any of the tenant, and I do respect that.
I'm going to interrupt you just for a minute. Is this not on the next? Yes, I think if you're speaking about a housing issue, I'm sorry to interrupt you, but that will be the next bill that we will.
Oh, I'm sorry. Okay, I'm not used to the process. I'm sorry.
That's
I'll
okay.
keep quiet.
That's okay. If you have anything you'd like to say about 1162, you may.
No, not at this point. That's the only thing I wanted to talk. Okay.
Okay, thank you.
Thank you. Sorry about that.
No
That's okay.
problem. Okay, let's see. Our next speaker. Let's see. We have Chrissy Hanisco. Okay, Ms. Hanisco, you should be able to speak now. Go ahead.
Thank you. Good morning. Can you hear me?
Yes, thank you.
Wonderful. Thank you. Good morning, Chairperson Hennessy and members of the committee. My name is Chrissy Hanisco. I'm an attorney in Concord, New Hampshire. I don't know if I need to state, I'm sort of alone in my room. My children could come in any moment. And I drafted this bill in response to a few different issues. First, potential clients were calling me frequently to try to confirm their parentage or to adopt a child. And in many situations, I had to tell them that they could not do what they sought to do under our current scheme. My primary practice areas are adoption and assisted reproduction. And I do want to thank Representative Butler and all of the co-sponsors for championing this bill. And I also want to recognize those who couldn't speak this morning, including my colleagues at GLBTQ Legal Advocates and Defenders, Resolve New England, and New Hampshire ACLU, who gave me vital input into the bill that I drafted. This bill will seek to modernize New Hampshire's adoption law, as well as add additional security for children conceived using third-party donor gametes. The focus of the bill is on who can adopt. That's under RSA 170B4. It will change husband and wife to 2 adults. The main goal with this change is to allow unmarried couples the ability to adopt. I think it's very important to note that we are the only state in New England that prohibits unmarried couples from adopting. There was a lot of disbelief in the House committee on this point, and I had to keep saying, no, this is really the state. This is really what we prohibit in this state. It will also aid the state of New Hampshire with dealing with children who need foster care and adoptive placements, because it will open up the number of foster homes available that would be seeking to adopt and can't currently because of their marital status. Second, it allows for step parents who are not married. I use step parents in quotes because that's not really how they're viewed. If the couple's not married, the child's non-biological parent has no rights and cannot adopt. This was specifically addressed in a 2019 New Hampshire Supreme Court case called JW. The lower court denied the mother's ability to adopt, and because the couple was unmarried. This was a couple who had been together for over a decade. They had 2 children in common. The parental rights of the biological mother had been terminated a couple of years earlier, and his partner was unable to adopt the child. The court invited the legislature to fix this issue. And finally, the bill gives parents 2 options for securing their legal parentage when one or both is a non-genetic parent. It would create, under the adoption statute, a confirmatory adoption process. This would allow a couple who use donor gametes, either egg, sperm, or both, the ability to secure the non-genetic partner's parental rights. It would also amend our surrogacy statute, which is 168B2, which is the section that addresses the parent-child relationship, by providing the non-genetic parent the ability to obtain a parentage order. Currently, that is only available to individuals and couples who use a gestational carrier. By giving couples either the option of the parentage order or a confirmatory adoption, it gives them choice, and it also provides legal security to the child or children who were conceived through assisted reproduction. This is important because it gives them more than a presumption. It's not just the presumption that the child was born of the marriage or that the person giving birth was the parent. It gives them a legal judgment that must be given full faith and credit throughout our country. And although we want to continue to move forward, I think we've seen clearly that there is still an undercurrent in society that is trying to take away people's rights. Recently, the Trump administration brought a case to the Supreme Court in just this past week to prohibit our LGBTQ parents from adopting. The remainder of the bill, which is really about updating to be consistent with these substantive changes and also to remove unnecessary gendered language. I really want to thank you all for your consideration, especially given this unique format. And I think I was more terrified to testify today than any other time. And I'm happy to take questions about the bill.
Are there any questions from the committee? Senator Chandley has a question.
Thank you. Thank you so much, Ms. Hanisco. Trying to understand sort of where you started and saying, a single person can adopt a child in New Hampshire. Am I correct about that?
You are correct.
So, but two single people ultimately cannot adopt a child.
Correct. So if So in my personal situation, when we were going through infertility, we were looking at our various options. We were not a married couple. And I was just absolutely stunned. I was a public defender at the time, so I was not immersed in family law, and was just stunned that we could not choose that option unless we married first.
And if I might follow up, the question I have, is there any kind of assumption or definition, in fact, that the two people share some relationship when in this kind of adoption?
We did not. We left that to the courts to assess. And I've talked to both. I've had inquiries. I've talked to other practitioners, and I've talked to some of our judges too about this. And there are times when, particularly when children have had tragedies in their families, either loss of parents through the opioid crisis or suicide or incarceration, where a grandmother and an aunt may want to pursue the adoption together, or a brother and sister, aunt and uncle. And it's usually the elder relative and a younger relative situation, which is sort of the more common, where the grandparent may be providing that care in immediacy and wants the security net for the child should something happen to them.
Okay, thank you very much.
Other questions? Seeing none, thank you very much for your testimony.
Thank you all very much.
And Senator, okay, let me just see. Senator Carson has a question. Yeah.
Oh.
Oh, sorry, hold on. Senator Carson? Okay.
Yes. Yeah, I had a question because I listened to the previous testimony, and I think there's a little bit of confusion here because the presenter started talking about two adults, but then she started talking about familial relationships. So what is this actually doing? Are we talking about two adults who have no type of relationship to each other? They're not married, they're not family. It could be two people who just, they might be friends who want to adopt a child, versus people who are family members where, as she said, you would have a grandmother and an aunt, or a brother and a sister. There's a big difference between those two types of relationships. And I heard her say in the beginning that they were going to leave it up to the court to determine the relationship. I just don't know if that's good policy. And I would like the speaker to clarify just exactly what she is talking about, because it is a little confusing. Thank you.
Yes, can you hear me?
Yes.
Yeah,
Okay.
I can hear you.
So yes, the bill would change the statute from husband and wife together to two adults together. We did not give further definition to what that relationship had to look like, but in my experience, it's not two random people. That's not what's happening. What's happening is different combinations of family are seeking to provide permanency and safety to children. And the more common is, the true unmarried couple that for their own personal reasons are choosing not to marry. So those are the two groups of people that are most likely to avail themselves of this. It's not going to be two random folks from the street. I think in the House, somebody proposed, I met somebody at the bus stop and, hey, why don't we have a kid together? That's not going to happen in practice. And if it did, that's where the court is going to assess whether the adoption is in the best interest of the child and whether this now couple that's come together to propose adoption is suitable.
May I follow up?
Absolutely.
Yes, follow up.
Okay, thank you. I hear what you're saying, but I think in legislation like this, it's better to try to put as many types of definitions in as you possibly can to give guidance to the court, as opposed to just letting the court decide. And in New Hampshire, our law currently states not what's in the best interest of the child, but what's in the best interest of the parent. So I think there's a presumption here that we are trying to do what's in the best interest of the child, where the statute really doesn't allow us to do that right now. So I just think there needs to be more definitions here as to when you define a relationship, what exactly is that relationship? Because I do think that there could be times where you have two people that really have no type of connection to each other, then they are in some sort of relationship. And I don't know if that's the right thing to do for a child. So it will be interesting to hear. I hope we have some folks who are child advocates that are on the line and are going to testify about this. I just wonder about the stability for the child if you have two adults that really have no type of connection to each other than they say we're a couple. And what's going to happen to the child at that point?
May I respond?
Yes.
I actually would respectfully disagree. The current statute 170B absolutely does not focus on the best interest of the prospective adoptive parents. It is focused on the best interest of the adoptee.
Okay. May I follow up, Madam Chair?
Yes, follow up.
Thank you. I think you misunderstood what I was trying to say. What I'm trying to say is I believe there needs to be more definition here when we talk about the types of relationship. We're talking about a child here. And we're talking about, if you want to talk about the best interest of the child, we want to talk about what's safe for the child long-term. I do think there needs to be more work done on this piece of legislation, more work done on defining relationships to give the court guidance. Thank you.
Are there any further questions? You don't see any, Tricia?
No. I have Santosh Salvi has his hand up with a question.
You may go ahead and ask.
Mr. Salvi, do you have a question?
Okay, I'm on mute. My question is, we need to figure out the stability of the relationship because we need to have a specific terms like how many years of relationship is called as a stable relationship for the safety of the child. We also find out about like what is the purpose of why they are trying to basically adopt the child. So we cannot just basically open it to every possible relationship and keep it open, and then the safety of the child will be in trouble. So I agree with the previous follow-up questions. We need a lot of work on this legislation, and we need to really be careful because we cannot just dump everything on the court, and then there will be lots of issues down the line. That is what I would like to comment on this. I'm all set. Thank you.
And Senator Hennessy, there are no other speakers on this bill. Oh, Senator, sorry, Senator LaRigg.
Thank you. And for the woman who is testifying, if that's possible, or anyone else.
Yes, I can get her back.
Can you hear me? We had heard that this type of adoption is done in other states. Do we know anything about what the ramifications are of two adults adopting children? Are there any facts that somebody can point to that raise concerns? And perhaps Chrissy, you could answer that question.
Yes, I think I'm back on.
Yes,
Yes.
you are.
Okay. In speaking, I'm also licensed in Massachusetts, and in speaking with colleagues throughout the New England states, we're not seeing that. I don't have actual data for you, but they're not seeing this as a problem. I'm not hearing of it in broader circles outside of New England either. It's a change that's been made in other states, many for quite some time now. New Hampshire has lagged behind in the gendered language of husband and wife together.
Thank you. A follow-up?
Yes.
Several years ago, when I was in the legislature, I thought we were working with bills on allowing LGBTQ parents to adopt. Is this still the case where married parents can adopt, and now we're just talking about unmarried couples?
Yeah. Yes, that's exactly correct.
All right, thank you.
If there are no further questions,
No, there are not, Senator.
okay, thank you. What I'd like to do now is to open the hearing on amendment no? Can't hear you.
We have to close. We have to close the hearing first.
Oh, I'm sorry. Thank you. Yes. So I'm going to close the hearing on House Bill 1162 at this time. And we are then going to go on to open the hearing on Amendment 1324. And I'm going to introduce the amendment, or the amendment 1324. After I introduce the amendment 1324, there will be another one, which is actually the same with one additional bill that we managed to get on at the last minute. So the bill 1162 is, should I be reading all of the bills on the first one? I'll just read you
Senator, I think what we discussed is that you'll just introduce the title of your amendment and then go into the second amendment after that.
Perfect, thank you. So 1162, relative to adoption and parentage, the Office of the Child Advocate, reimbursement of court-ordered services for juveniles, the legal representation of children in the juvenile justice system, the best interest of the child under RSA 169C, and the duties of the Oversight Commission on Children's Services, insurance coverage for children's early intervention services, expanding the family-centered early supports and services, FCESS program, to children under the age of 3 who are born substance exposed, the Child Abuse and Neglect Central Registry, establishing a kinship navigator program in the Department of Health and Human Services, and relative to missing children. And what I will do now is to introduce 1396, which, and I will list the individual bills. It has the same description with adding the final bill at the end, which is relative to dispositional hearings under RSA 169B. So I'll now read the list of bills that are in 1396S, which is an amendment to HB 1162. The first one is HB 1162, relative to adoption and parentage. Number 2, SB 295, relative to the Office of the Child Advocate. The third, HB 1657, relative to reimbursement of court-ordered services for juveniles. HB 1249, relative to the legal representation of children in the juvenile justice system. HB 377, relative to the best interests of the child under the Child Protection Act. HB 1233, relative to coverage for children's early intervention services with change regarding high deductible plans. HB 1707, expanding the family-centered early supports and services FCESS program to children under the age of 3 who were born substance exposed. SB 541, relative to the Child Abuse and Neglect Central Registry. HB 1637, establishing a kinship navigator program in the Department of Health and Human Services. SB 643, relative to missing children, and HB 1597, which was inadvertently left out initially, relative to dispositional hearings under RSA 169B. And what we'd like to do at this point is call on any members. No, what we're actually, because I apologize. And we're going to see if Senator Morgan is available to speak to the bill that that he would like to include in the process and introduce his amendment. Is he?
Yes, Senator Morgan, go ahead.
Thank you, Madam Chair. For the record, my name is Senator John Morgan, proud to represent Senate District 23 in New Hampshire State Senate. The bill that I would like to respectfully request the committee consider including in this this omnibus child protection package would be Senate Bill 549. And if you just give me a moment, I'll briefly speak to Senate Bill 549 and respectfully request any technical or specific questions related to the package would probably be best answered by the department. But for the purposes of an introduction, this is for you. In December 2016, the Center for the Support of Families issued.
Sorry, Morin,
Yes.
so sorry to interrupt you. Just to clarify, you want to introduce the amended language to 549, which is Amendment 1110S, I believe.
That is correct.
And I
Yes.
believe that we're going to put that up on screen and it should be available online as well for members of the public to examine.
Thank you very much. All right. This is the correct amendment. In December 2016, the Center for the Support of Families issued the New Hampshire Child Welfare Quality Assurance Review of the Division of Children, Youth, and Families, a report with recommendations for improving the state's child protection system. The report by the Center for the Support of Families further recommended that the state revise policy and/or statute to clarify that if the evidence in an assessment indicates that a child has been exposed to conditions that place the child at risk of future harm, the report should be determined founded and services for the family put in place. Protections in this bill are for the children of New Hampshire who are at risk of harm and abuse and neglect when there is exposure to substance misuse, domestic violence, or psychological maltreatment. Current law is scheduled to sunset on June 30th, and Senate Bill 549 is necessary to fill the sunset gap. And this amendment 1110S would do that. The department worked with OCA, Waypoint, and HLA, who expressed concerns at the hearing to reach this proposed language. They also worked with CASA, Dartmouth Hitchcock, New Futures, and the Coalition Against Sexual and Domestic Violence, and all parties are on board. That concludes my testimony, and I'd be happy to attempt to answer any questions.
Thank you, Senator Morgan. So do we have any questions, Tricia?
not. Oh, Senator Carson has a question?
Senator Carson.
Thank you, Madam Chair. Where is this amendment? I'm looking online. I don't see it anywhere. And I don't feel comfortable voting for something when I can't see it.
I can send you the link, Senator. It's on the general court website where the hearing is posted on the main page, but I'll send it to your chat right now.
Okay, thank you.
Okay, I do not see any other questions for Senator Morgan.
Okay, then we will close the hearing on the amendment that Senator Morgan.
No, Senator, no, we have a number of speakers still to speak on the amendment as a whole.
Right,
Oh, I'm sorry. So we're on his amendment, I meant,
Yeah.
no? Okay.
on the amendment as a whole.
So we're not closing anything yet.
I'm just
Okay.
asking you to add this into the amendment.
Okay, perfect.
Thank
So we have speakers on the,
Yes.
okay.
So our first speaker next is Moira O'Neill. Okay. Miss O'Neill, you should be able to speak now.
Good morning. Can you hear me okay?
Yes.
For the record, my name is Moira O'Neill. I'm the director of the Office of the Child Advocate. Thank you, Chairwoman Hennessy and Chairman Chandler, for the opportunity, and the rest of the committee for the opportunity to speak to you today and express support for Amendment 2020-1324S to House Bill 1162 relative to adoption and parentage. Of the original bill on adoption and parentage, we certainly appreciate that New Hampshire has the opportunity to update legal avenues for accommodating various constellations of families. In my work with the Office of the Child Advocate, I've learned from children that there's nothing more important to them than family, whatever it looks like. So this is a good opportunity. To Senator Carson's concerns about best interest, in item 37 of this amendment, there is an intention to elevate the best interests of children in the purpose of 169C2, the Child Protection Act. So that may not be directly related, but then item number 38 would mandate the Oversight Commission on Children's Services to review the entire chapter and also all other statutes for sensitivity to children's best interests. So if it isn't immediately addressed in this amendment, I think there's an opportunity for us to look at all New Hampshire statute to make sure that children's interests are elevated to the prime concern. So I hope that will address that issue. I've already appeared before this committee to support the proposed changes to the Office of the Child Advocate in Senate Bill 295, and we're grateful to Senator Carson for her constant support of our office and her of that bill. And so, of course, we still support it and we appreciate that it's here in this amendment. The COVID-19 pandemic has underscored the need for these changes. And just briefly, for an example, we know that there have been a number of children who have been placed in residential facilities who have been infected by that virus. But we're only able to monitor the care of 11 of those children. I had submitted written testimony that says it's 10, but actually we heard yesterday about another one. And we're able to monitor and make sure that they get the care they need. But we're not able to monitor all of the other children who are placed in residential facilities by other authorities, for example, by education. And so we're very concerned that there are children who aren't getting the benefit of the Office of the Child Advocate's oversight. And we're really seeing that now in this pandemic. So I'm grateful that you recognize the necessity for the care of all children to be assured proper oversight, especially those who are placed away from their families. In regard to Senator Morgan's amendment to the amendment, as I understand it, he's proposed including updating the rebuttable presumption option, which we think is very important. And actually, I was troubled that it wasn't included originally in this because that's a very important piece of legislation. We see all the time Yes.
Chair, I'm so sorry to interrupt. However, Ms. O'Neill's time is up.
Okay, thank you. And otherwise, we support all the rest that's in the bill, and thank you for this opportunity. I'm welcoming questions if you have them.
Are there questions?
Not see any questions? No?
Okay,
Okay, thank
Thank
you.
you.
Thank you so
Okay, our next speaker is Sue Chang. Okay, you should be able to speak. Sue Chang. Okay. If you're having trouble, if you want to get back on, you can raise your hand and we will call on you. Otherwise, we will go to the next speaker, who is Tyler Brannon. Mr. Brannon, you should be able to speak now.
Thank you. You should be able to hear me. Tyler Brannon, I'm the Director of Health Economics with the New Hampshire Insurance Department, and I'm going to focus on a relatively narrow part of the amendment. We don't have a position on the bill or the amendment, but we are in favor of language that addresses what's referred to as sort of high deductible health plans with a health savings account arrangement, which provides certain tax benefits to individuals and employers. And the language in this section relates to cost sharing for early intervention services. And there is language in there, and this is the language we think is important, that provides an exception for these high deductible health plan HSA type arrangement products. It's actually tax law, it's not insurance law, but when we make changes to the insurance statute, we just have to be careful about some of the tax ramifications. So I just wanted to bring attention to the fact that this is an insurance change, but the insurance department is watching to make sure that the legislature is advised in ways that won't undermine the benefits that come with some of these products. The only other thing I would mention is just generally speaking, it may be good policy to reduce cost sharing for certain services, but generally speaking, when you do that, it does put certain upward pressure on premiums. It's a bit like a hydraulic, and of course the opposite is true too. If you want to bring down your premiums, people tend to see higher cost sharing. So that's all I wanted to contribute. Thanks for the opportunity to testify, and happy to take any questions. And the section I am referring to is on page 17, section 39. Thank you.
Are there any questions?
I do not see any here, Senator.
Well, thank you, Tyler, for your testimony.
Thank you.
Okay, we will go on to our next speaker, who is, excuse me, Rebecca Ross. Ms. Ross, you should be able to speak now.
Thank you. Good morning, members of the committee. My name is Rebecca Ross. I am General Counsel for the Division for Children, Youth, and Families. We have already testified before this committee on the substance of a number of these bills, and we would ask for your consideration and continued support of the Central Registry Bill, which was Senate Bill 541, the Missing Children portion, Senate Bill 643, and Senator Morgan's recent request to amend to add the rebuttable presumption bill that the OCA had also spoke about the collaboration and support and the revisions that were made at the request of the members of the committee for us to go back and work on that. I will not add further substantive testimony today, but I'm happy to take questions about any of those sections at this time.
Any questions? I do not see any here either. We will go on to our next speaker, if that's okay, Madam Chair.
Absolutely.
Okay, our next speaker is Mr. Salvi. Mr. Salvi, do you want to speak on this amendment?
No. I'm all
Okay.
set. Thank you.
Thank you. Okay. Okay, our next speaker then is John Dejoy. Okay, Mr. Dejoy, you should be able to speak now.
Good morning, Madam Chair. Can you hear me?
Yes.
Okay. Madam Chair, members of the committee, for the record, my name is John Dejoy, and I'm pleased before the committee. Just for clarity, I submitted 2 pieces of testimony, one on behalf of Waypoint and the other on behalf of the Juvenile Reform Project. Waypoint supports the bill and the amendment, specifically the pieces involving Senate Bill 295, which just passed the House committee with a vote of 18-2 last week. I'm speaking this morning, though, representing the Juvenile Reform Project. We're in support of House Bill 1162 and the underlying amendment 1324S. The Juvenile Reform Project is comprised of several organizations working together to modernize the juvenile justice system and advocate for a robust system of care, which provides better outcomes for children and their families. The Reform Project is comprised of Waypoint, Disability Rights Center, New Hampshire ACLU, New Hampshire Legal Assistance, and New Futures. I want to highlight, I'm not going to offer new testimony. We've worked on a number of these bills through the session, but I do want to highlight 3 bills in here that are of significant importance to the Juvenile Reform Project. And those are House Bill 1249, relative to counsel for juveniles, House Bill 1657, relative to parental reimbursement of juvenile justice programs, and House Bill 1597. As I said, we're in support of all of these and the amendment, and we ask the committee's support of both the bill and the amendments. And with that, I will end my testimony.
Okay.
Thank you. Are there any questions for the speaker?
I do not see any on my end, Senator. Okay.
Thank you, Mr. Dejoy.
Thank you, Madam Chair.
Okay, our next speaker, and this is the last speaker on the list. So if anybody else would like to speak after this, please raise your virtual hand or dial *9 if you are calling in. We have Michael Skibby. Mr. Skibby, you should be able to speak now.
All right, can you hear me?
Yes.
Welcome.
Thank you. My name is Michael Skibby. I'm the Policy Director for the Disability Rights Center. I'd like to address 2 areas in the amendment. And if time, I'd like to address the last bill that was just added. They all arise from the work of the Juvenile Reform Project, which was described to you by Mr. Dejoy. First, the provisions found in sections 30 through 36 of the First Amendment, starting at the very bottom of page 42 of the calendar. This is the language from House Bill 1249, a bill which received overwhelming support in the House, both in the committee and on the floor. It's co-sponsored by Senators Hennessy, Carson, Reagan, and Bradley. This provision would ensure that kids that are placed by courts outside their homes receive the continued assistance of counsel. Current practice, which may be unconstitutional, is for lawyers to close their cases once the court makes the placement, leaving kids without meaningful recourse if they're subjected to maltreatment or encounter health problems or inadequate services. This is an area that is of particular concern to my office because we often investigate cases involving abuse or neglect of children with disabilities in residential facilities. And we're very concerned that children who may not be receiving appropriate treatment and may not have a well-functioning family to turn to do not have a lawyer that they can call to help with recourse in the courts. Please note that during the current pandemic, the Judicial Council, Circuit Court, and Public Defender agreed to implement the requirements of House Bill 1249 on an emergency interim basis. So we know that this will not be a problem to implement permanently. We also are confident that it will protect children and over time will save money in many cases because children will return to their homes earlier than they would if they did not have a lawyer. The second issue is in sections 12 through 29, starting on the bottom of page 38 of the calendar. This is from House Bill 1657, co-sponsored by Senators Hennessy, Chanley, and Bradley. It also received very strong bipartisan support in the House in both the committee and the floor. This would eliminate the requirement of parental reimbursement for court-ordered services for kids. This will remove the disincentive to agree to services earlier in the child's life when they're likely to have greater effect than services provided later. This may save money over the long run by keeping kids in their homes due to earlier intervention rather than waiting for more difficult behaviors to develop, with more restrictive and expensive services being ordered in response. It's a way to help support families dealing with their children's needs and is likely to reduce the extent, intensity, and expense of later court involvement. The last item is the bill that was just added, House Bill 1597, relative to dispositional hearings under RSA 169B. This would assign a service coordination agency to kids upon their admission to the Sununu Center rather than waiting until they're close to discharge. Senate Bill 14 last year created the requirement, but this bill will get the assignment done earlier in the hopes that discharges will happen sooner because services have been arranged sooner. That bill also received overwhelming support. Thank you. I'd be happy to answer any questions.
Thank you. Are there any questions for Mr. Skibbe?
Senator, I do not see any on this end. And is there anybody that would like to speak on this amendment? Please raise your virtual hand or dial *9 on your telephone if you are calling in. Okay. I do not see any hands raising, Senator. So
Thank you. So in that case, it is time to close the hearing on House Bill 1162 and the amendment 1396S. And we will go on to open the hearing on House Bill 1247 and call on the prime sponsor, Representative Conley, if Representative Conley is available.
Representative Conley, you should be able to speak now.
Hi, everyone. Thank you very much, Madam Chair. Thank you. For the record, I'm Casey Conley, State Representative from Stratford County District 13, that is effectively downtown Dover. HB 1247, as amended by the House, would require 60 days notice for rent increases that exceed 5% and 90 days notice for increases that exceed 8%. The affordable housing shortage, and I guess the housing shortage in general in our state's been well documented. Vacancy rates across all rental housing as of the spring was less than 1% in most New Hampshire counties. So the whole idea here is to give tenants as much advance notice as possible about future rent increases. As you might expect, a rental market that is very tight has seen very surging rental increases. So Stratford County, where I live, average rents have risen by 33% in 5 years. Rockingham and Hillsborough counties during that same period, rents have risen by more than 25% on average. Even in Coos and Grafton, rents are rising faster than inflation. So another point I'd like to make is that 30 days, which is the current standard for notice of increases, is not enough time to find suitable replacement housing, probably in any market, but let alone a very tight one. You can't just expect, if less than 1% vacancy rate, that you could find a new apartment that you can afford that's available, around the corner, or even, in another part of your city or town. Not hard to imagine people being forced to move to another place, to change jobs, to have to take their children out of school, and so on, based on their lack of ability to find suitable housing where they live. It's also not a stretch to imagine how this could lead to homelessness. So finally, I just want to make clear, this in no way restricts what any landlord can charge any tenant in rent. It only specifies a certain period of notice for increases that exceed a certain percentage of the prior agreed upon rent. And lastly, Madam Chair and Senators, I just want to say I approve of the amendment and I support the amendment that has been proposed for this bill. And with that, I'm happy to take any questions.
Thank you. I see Senator Chanley has a question. Is that correct?
Yes. Go ahead.
Okay, thank you. And thank you, Representative Conley, for being here this morning. I completely understand your concerns about affordable housing and the our housing shortage. What I'm sort of trying to figure out is how this would help. Because I did understand you to say this was a way of addressing that, or am I wrong? Did I not understand that? So I may have misunderstood, but I don't see how the 60 or 90 days necessarily helps to address our housing shortage.
Senator, thanks for the question. That was more of context and background for the current situation. Nothing in this bill, I don't expect, would alleviate that. It's more identifying the challenges that people face and explaining why this bill, I think, is necessary. The fact that the market is very tight, costs are rising, and people are having difficulty finding new housing. That's it. And I hope people can't hear the chiming that's happening on my computer right now. But
yeah, that's all right. That's life in Zoom. And if I might follow up, so I guess the other thing, how did you arrive at the two triggers, rather than just having a single trigger? Why are there two triggers, and what's the advantage to doing it that way instead of just having a single trigger?
Thank you, Senator. That emerged from a House subcommittee that formed to address this particular or that particular question. So and I believe other speakers can address this as well, but the goal here is to align, 5% is in the, probably for most people, the upper range of affordability, right? Most people aren't getting a 5% raise, and certainly most people aren't getting an 8% raise. So it just is intended to provide additional time, particularly with the 8% trigger, for rents that far exceed what most people can generally expect to afford in a given year-over-year increase.
Thank you.
Anybody else who wants to ask questions?
Do not see any on this side. And we will go to the next speaker. It's Elliot Berry. And right here.
Can you hear me?
Yes, we can.
Hi. Thank you very much, Senator. My name is Elliot Berry. I'm the Director of Housing Justice for New Hampshire Legal Assistance, and I have been practicing, especially in the landlord-tenant area, for over 40 years. I just want to run through a couple of key things that are not patently obvious from the bill. Number one, it does exempt a number of what you would call small landlords. You can see that at the very top of the bill, including people who own 4 units or less, even if it's not owner occupied. It exempts single family homes. We're really talking exempt subsidized housing where the tenant's rent is based on their ability to pay, not the full contract rent. And exempts manufactured housing because they already have their own provisions. I want to talk a little bit about the extraordinary dimensions of some of the increases that we were seeing pre-COVID. We have seen, and these are just examples from my actual caseload, in Concord, $300 a month increase. West Lebanon, $300. Nashua, $595. Newport, $600. Keene, $550. A Manchester case at $450. And I've seen $150 increases all over the place. People can't, and I'm not saying these are averages, but people can't possibly pay these rents, and they need time to find alternatives. The other thing that I want people to understand, just to give you an example, if you have somebody paying what is today a fairly ordinary rent of $1,200 a month, if the rent increase is less than $60, this bill has no effect on them whatsoever. If the increase is between $60 and $96, they only have to give 60 days notice of it. and you only have to wait the 90 days to the extent that it is over $96 a month. So the vast majority of rent increases will probably not even be affected. I know some people will come and comment on the fact that property taxes don't have that kind of lead time sometime, but landlords should be able to have enough cushion to be able to wait between 60 and 90 days to implement those increases. But if they had to borrow, say $100 for each unit, the delay of 6 months would cost about, on an 8% 15-year mortgage or loan, would be less than $6 a month. And again, as Representative Conlon said, once this notice period is over, there is no effect whatsoever on how much the landlord can charge.
Mr. Berry.
So that's my comment on the original bill, on the bill as come over.
Madam Chair, I'm so sorry. The 3 minutes is up for Mr. Berry.
Thank you.
Okay. I do not see any questions.
Senator Chanley has.
Senator Chanley, sorry. Sorry, Senator. Oh.
There you go. So part of me is always trying to figure out whether it's quicker for me to raise my hand in the chat or just wave on the screen. So I apologize. And thank you, Mr. Berry, so much. I have, essentially 2 questions. And the first question is, if, I'm hearing from the testimony that rents are going up a lot. Do you think that those rents have been under market for a while, or why?
No, not at all, Senator. I think they're going up because the supply and demand is so skewed in favor, the supply is so limited that what you're getting, so some of it is just taking advantage of that, but the other piece is that the buildings are getting sold right and left again, and the new buyers, have new mortgages and, trying to take advantage of the hot market. But we definitely see most of the huge increases in people in situations where a new buyer has taken over the building.
Okay. My second question.
It's pure speculation, as I see it.
Okay. My second question, just if it's okay to follow up, is just relates to, do you foresee any unintended consequences here, such as the administration of other kinds of fees or anything that would in any other way harm tenants if landlords feel obligated to provide this extra time?
No, I don't think so. I mean, right now, once upon a time, the 30-day notice, may have been problematic. I think they get used to it. And I just don't, it's a very simple process. You can handwrite the notice yourself and give it to the tenant. It's just all about giving the tenant time to figure out how they're going to respond and to begin looking for a new place. But no, I don't see any unintended consequences. I'm sure some people will say, well, landlords will have a disincentive, but I can't figure out why that would be. Again, all you're doing is delaying the rent increase. And if the landlord anticipates it ahead of time, they can give the 60 or 90-day notice before the lease expires, so that upon the expiration date of the lease, they've already fulfilled their obligation.
Thank you very much.
You're welcome. My pleasure.
I do not see any more hands raised for questions here, Senator Hennessy.
Thank you. Are there others who are going to speak to the bill itself?
To the bill itself, yes. Okay. Okay, and if I would just like to remind the speakers, when I call on you, we are speaking to the bill right now and not the amendment. The amendment will have a hearing after this bill hearing. Thank you. Okay, and the next person I have on my list is Matt Mending. Okay. He is not on right now.
Can you hear us?
There you go. Thank you.
No
Yes,
worries.
we
Good
can hear you.
morning. This is Matt Mending from Elm Grove Companies. I'm here in the room with my partner, Chris Schleier. We own and operate a property management company with about 1,500 units under management. So we wanted to take the opportunity to comment for our own portfolio, but for also a number of our property management clients that we represent. So there's two primary things. We're in opposition of this bill, and I understand that the amendment will come later. So I'll stick to just the original bill. I think everyone knows that there is an affordable housing crisis in New Hampshire and in the country more broadly. And generally, you know, on the surface, maybe it doesn't seem like this is an unreasonable request, but the more and more barriers that are put up for developers and owners of rental property just adds cost and adds difficulty to something that Elliot Berry even mentioned is a supply side issue. We don't have enough rental housing. So each little piece of a barrier that continues to be added to that problem makes it more difficult, more costly to develop, to add new housing, or to even just maintain the housing that we have. So, you know, we don't want to take an unreasonable stance on this, but at the same time, I think that the conversation more broadly needs to be about how do we remove barriers, how do we make owning and operating rental property less difficult so that more people get into that business, we add to the supply, and we really build the housing that we need. Vacancy rates are tight. You know, a lot of what people are saying around this issue is true, but adding barriers, in my view, is not the way to address this. It's, you know, the topic rent control, whether this is rent control or not, has been brought up, and you could argue that both ways. But, you know, things that head towards rent control, if you look at the data and the history, do not solve the affordability of housing or the supply of housing. So that's one thing that is just an important point, I think, as we're talking about any new barrier or difficulty in owning rental housing and operating it and providing that to residents. The other important piece, though, is that this seems a bit unnecessary. Landlords and tenants for many decades have always been able to create leases that are satisfactory for both parties. That could include automatic renewals. It could include rent limitations. It could include a stipulation that there will be a contact 60, 90, 180 days prior to the lease expiration to renegotiate a renewal. I think contract law is serving its purpose very well in this case. And at any time, resident or landlord can act to extend a lease. People do 24-month leases sometimes. People do 36-month leases. We personally start our process 90 days prior to lease expiration for renewal because, you know, this is a business. We need to be competitive. We want to provide a good service to residents. So there's not really a need for this to be legislated. The contract law that exists already can be utilized by both parties to come to a mutual agreement rather than making a broad brush type of approach. Chris, was there anything you wanted to add to this?
No, I think you covered it well.
Okay. Thank you for the time of the committee, and that wraps up our comments.
Thank you.
Okay.
Senator LeBake has a question. You're on mute, Senator LeBake.
Thank you, Madam Chair, and thank you, Mr. Mending, for your testimony. Mr. Mending, do you foresee that in this time of COVID, with the economy being down and jobs being more scarce, that people may need to have more notice in order to pay their rents when they increase? And therefore, that may help you maintain clients as well, or renters.
Yeah, I think that becomes overtaken by the reality of the economy. We've frozen our rent increases. Our goal is to maintain the residents that we do have rather than trying to put any unneeded burden. So I think that the market is speaking pretty loudly with all the job losses that we've had. There's been other testimony for the Gopher board that our company's participated in where collections have been good, but my understanding is that the unemployment benefits will be running out July 31st. And so I think there's going to be significant downward pressure on the rental market. So even if we wanted to raise rents, I don't think that we could. And I think that many landlords are going to be seeing things the same way. The economy and the market speaks for itself. If people aren't making money because they're not employed, they're not going to be able to afford additional rent. They're not going to be afford a lot of things that they are when they were gainfully employed. So we're trying to hold on to our people and when work with folks. We've already waived late fees through COVID and gave $50 credits for on-time payments. So, we see what's happening in the world, and I think that the market's kind of the driving force right now.
Thank you. I commend you for freezing your rates and trying to work with your renters. That's a good practice. Thank you.
Are there other questions?
Senator French, you should unmute and then you can go ahead. Oh, can't hear you. Do you see, I requested that you unmute. There should be a little button you can hit.
It said the host has muted him. I don't know if that helps you.
Yeah, I'm hitting ask to unmute. Ava, can you try?
I think that we had some IT technical difficulty that may have screwed things up a little bit. Senator French, could you possibly, while we're trying to figure out, type your question into the chat box and Senator Hennessy could read it for you while we try to get you unmuted?
Oh, he's gone.
He just came back.
Okay, here he's coming.
We back?
Yes, go ahead, Senator French, we can hear you.
I lost the screen for a second. Just for disclosures, there are times in my business ventures that I work with Elm Grove, and I just want to put that on the record.
Thank you. Did you have another question, Senator?
No question, just a statement. Thank you, Senator.
Thank you.
Okay. All right, our next speaker is Mr. Salvi is signed up. I will check with him. He is not here anymore. Okay. I will go on to the next speaker for the bill. We're speaking on the bill still. It's Sarah Noy. I do not see Sarah Noy. If you are calling in, Sarah Noy, could you please dial *9 so that your hand will raise? And then we will go on to the next, which would be Nick Norman. Okay. There we go. Mr. Norman, you should be able to speak now. Mr. Norman, can you unmute yourself?
Okay, I got it. I didn't
Okay.
realize you were sending me a prompt to unmute. All right, thank you very much for having the opportunity to speak to you. I realize we're speaking only to the original bill. I have many more comments on the amendment. I did send a written testimony in email this morning so that everyone should have it. Please refer to that. There's some unintended consequences that I don't think that anyone is really thinking about. So I want to highlight this. I also agree with the things that Matt Mending said from Elm Grove. Right now, a tenant is required to give a 30-day notice when they want to move and terminate a lease. If you create a situation of having a 60-day notice for rent increase or 90-day notice of rent increase, but only 30 days notice from a tenant to leave, you create an imbalance in the whole rental market that essentially is designed to increase rents. So if you think about it, someone gets a 90-day notice or a 60-day notice that their rent's going to increase. They're starting to look for apartments. There are no apartments available that have a 60-day window. The tenants leaving are only giving 30 days. That's going to make it so that landlords are going to get a huge amount of calls for apartments they don't have. That's going to drive up rents. You're going to increase the exacerbation of a low supply and greater demand. If you're going to have a 90-day, 60-day notice of rent increase, you need to have equally balanced on the tenant side, 60 and 90-day notices to vacate. I agree that everything that you want to accomplish here is already accomplishable with contract law. Don't see any need for this provision. It is an initial step at rent control, and rent control has over and over and over again been proven to be a failed policy and just exacerbates the situation that it was originally trying to solve. I agree, we do not need to add more barriers. More barriers is going to just make the whole housing market even worse. Also, this would discourage month-to-month tenancies. And month-to-month tenancies are needed by a good number of people. There's a lot more in my written testimony, which I have emailed to you. I highly encourage you to please read through that, and my contact information is in there. Please call me, and I'm happy to answer any questions on this portion of the bill.
Let's see.
Senator LeVesque has a question.
Okay, go ahead.
Yep, thank you, Madam Chair, and thank you, Mr. Norman, for your testimony. Two things. Are we assuming that anyone who has their rent raised will be leaving, looking for a new apartment or housing?
So I'm saying that that won't necessarily be true, right? Not everyone that gets a rent increase will be moving. But if you have it so that rent increases are 60 and 90 days, you're going to create this imbalance that's going to drive up and exacerbate the cost of rent for those people that are moving in 60 and 90 days.
Okay, thank you. All set.
Okay.
Any other questions for Mr. Norman?
I don't see any. Okay. Our next speaker is Patricia Murphy. Ms. Murphy, you should be able to speak now.
Good morning.
Good morning.
Good morning, Madam Chair and committee members. My name is Patricia Murphy, and I am the president of the New Hampshire Local Welfare Administration Association, and I'm also the welfare administration for the town of Merrimack. I did email in a written support for House Bill 1247, so hopefully you should have that. But on local welfare, we are sort of the frontiers in our local communities on poverty. We are mandated by state law to provide a most basic need to our communities, and housing is a basic need. Usually housing is actually almost 90% of local welfare budgets. So whatever happens usually to housing, especially rents, is definitely affected on the local welfare budget and those that we have to budget for our local communities. Rents have skyrocketed and created financial hardship for families, disabled and elderly. And we're seeing many people their rents are almost 70 to 90% of their income. So it is a very big difficulty right now. In response to the testimony that this law is not needed, most landlords, I would agree, are reasonable, but the law would focus on the rare landlords who I don't consider are reasonable and not sensitive to their clients' inability to pay. So I would suggest that, people who are reasonable will actually not be affected by this law. The response to that it affecting an imbalance on the 30-day notice requirement for tenants to quit. I usually find that most landlords appreciate the fact that if tenants can no longer afford to pay rent, that they're moving on quickly so that they can get someone in there who can afford to pay the rent. So I think this would be an advantage, that a landlord wants to see get someone in there. In today's market, that's not usually a problem. So we support House Bill 1247 because it makes sense for the tenant who, for no fault of their own, needs to find time to find more affordable housing if they cannot afford this rent increase. If municipalities have to subsidize the difference of the rent, it eventually increases the local taxpayers' cost, and this increases, the cost for everyone. And just with that brief, I have more information on the amendment that I will be talking to, but if anybody has any questions, I'm here, happy to answer.
I do not see any on my end, Senator Hennessy.
Oh, I see Senator LeVake's hand.
Okay.
Okay, thank you, Madam Chair. And thank you, Ms. Murphy, for your testimony. Do we know how many renters leave after a rent increase?
I don't know exactly what would be the statistics for that, but I do know when people come to our office and they cannot afford the rent, then basically they have no choice but to consider leaving because of the fact that it's not something they can afford to go forward with. It leaves them no choice but to do it. But that statistic I do not have.
Okay, thank you. And to follow up?
Follow up.
Do you feel that with a longer notice, they may have an opportunity to work this into their budget?
It depends on whether they have a fixed income or not. Some people can get a second job, maybe get more income. But if you have an elderly person or disabled person who's relying on Social Security income to pay the rent, this is not something that they usually have an option.
Okay, thank you.
Hey. I do not see any more questions over on my end, Senator.
Okay, excellent. We are going to close the hearing on House Bill.
I'm sorry to
Nope.
interrupt. We just got one registered Representative Timothy Horgan wanted to speak to the underlying bill on 1247 if he is in here.
Okay. I do not, did he call in, Alan? I do not see him yet.
He literally just registered
Okay.
1 minute ago. So
I do have a hand raised. Jessica Margison would like to speak. Should I take her now, Senator? And
Certainly, and then when Representative Horgan comes in, we can hear from him.
okay, okay. Ms. Margison, you should be able to speak now.
Hi, thank you very much for letting me be able to speak right now. I didn't have much time to go over the bill, but what I have read and been able to listen to, I agree with a lot of people. The previous speaker, Elliot Berry especially, while we might have a few good landlords right now that have done some stuff to help, we still have the need to protect those who haven't. The vast majority of landlords aren't able to actually just lower the rent or freeze everything. We can't rely on a few good landlords making sure everybody else does the right thing. The housing market patterns, every time we have a seller's market, our rent goes high. Every time we have a buyer's market, rents do go down. Right now we have a seller's market. We have a less than 1% vacancy rate. Rent is currently high because of the supply and demand. It shows itself every time we go through these bubbles. I'm hoping that if we can't do the bill as it's written, that you guys can consider something as a staggered increase. Anything over a 5% increase after a 30-day notice, they would have a couple months and it would go up in staggered amounts till they can meet it or be able to move. Rents are commonly 50 to 90% of one's income. My current rent is 75% of my income, and I am disabled. For me to move, it could take up to a year to save a security deposit because it takes 30 days to get that security deposit back. I, as an advocate, have seen many ways that landlords have tried many underhanded things to get and keep that security deposit. They can't rely on that coming back to them 30 days later. So they have to all of a sudden come up with $1,000 to $1,500 just for a security deposit to move. People in that situation don't have access to that. That puts a further burden on community as such as the welfare and then local community agencies that are already stressed and maxed before the pandemic hit. It does not create what he mentioned. I tried to raise my hand during that. It doesn't, what is the wording he used? It doesn't lead to, what is the word with rent? They're worried about it being rent control. It's not a type of rent control. It's for people's rights. It is what it is. Income compared to rent is what it is. People need the time. Hold on 1 second. Make sure I just got everything I wanted to speak on. It's just basically that people do need the time. We have the less than 1% rental market. You can't find a place. People don't have the access to the funds to be able to save to move as quickly. And if it is increased, they need some type of staggered approach to be able to meet the need.
Are there any questions for the speaker?
I did want to throw out there, it may be mentioned sometime. I think this leads into the rental price going up. I myself used to be on Section 8 years ago. What happens when you are on Section 8 as a tenant, you go in at a certain rate. What you'll notice if you look through all the Section 8 records is that rents will commonly go up with a Section 8 tenant, much more than other rents will in this general area. They will go up to the maxed out amount. When this happens to a large portion of apartments in a city, other landlords see that amount. They start matching to theirs to that amount because they can get it.
Interrupt, Madam Chair, but the 3 minutes is up. I'm sorry.
That's fine. I got it in there. Thank you.
You got it in there. Thank you. So are there any questions currently? I think Tricia is muted.
It's okay. Trisha had to step away, so I'm stepping in as co-host, but I don't see questions or hands raised from committee members for Ms. Margison. So if we're all set there, I can move on to the next speaker.
Excellent. Is Representative Horgan available?
Yeah. Got
Excellent. Thank you.
Representative Horgan, and he should be all set and to unmute, and you're unmuted.
Oh, thank you very much, Ms. Hawks. Thank you. I feel bad I caused a little bit of a confusion. I decided
I've been watching on the YouTube. I decided to comment. I was inspired by Mr. Norman. He's talking about the market. Well, the rental market is far from free. Well, the whole free market paradigm, the economy has collapsed. We've had the pandemic, so we're gonna be doing everything differently in the years ahead anyway. But in any case, a free market or any type of market can't function without transparency and pricing. So this bill is a pro-free market, pro-transparency bill. It just requires the landlord to inform the tenant what the price is going to be in enough time for the tenant decide what they want to do, whether they want to stay there or find somewhere else to live. And I know these are tough times for landlords. They're tough for everyone, but they're probably in a better position than a lot of people because even before everything fell apart, they had rents that were basically about the highest you could possibly charge working people and still find people want to pay them. They had a vacancy rate that's near zero, and of course, as was also pointed out, it doesn't do anybody good to have people in your property who can't pay the rent. You'd rather have them move on somewhere cheaper. So I think this is a pro tenant bill, pro free market bill. It's a market that's highly imbalanced towards the landlords. It's very much of a seller's market. So tenants are at a huge disadvantage as it is, and this just makes it a little bit easier for them. So I say that we had a very spirited debate on this in the House Judiciary Committee, which I'm a member of, and I'm just speaking as one member of the committee. I was not the member who wrote the majority report. So I urge you to pass this, and although we're not debating the amendment to the amendment is good, there may be some things I might say differently if I was writing it, but I think it's a good amendment, and both these bills are needed to help both tenants and landlords deal with the emergency that we're all facing. So thank you very much, and I'm glad you were able to accommodate me for a few minutes. I apologize for making extra work for everyone. Thanks.
Thank you, Senator Horgan. Representative Horgan.
Yeah.
Are there any questions for Representative Horgan, or we move on?
I don't see any here. Nope. Okay, we do have one person with their hand raised, Senator Hennessy, that would like to speak. Elisa Margolin.
Okay.
Go ahead, Ms. Margolin.
Good morning, Madam Chair, members of the committee. I apologize. I thought I had registered to testify both for the bill and for the amendment. My name is Alyssa Margolin. I serve as Director of Housing Action New Hampshire. We're a statewide coalition of 80 organizations working to improve state and federal policy so everyone in New Hampshire has a place to call home. Our members include affordable housing providers, both nonprofit and private, as well as homeless shelter providers, public housing agencies, and supportive housing providers. So many of our members are landlords, and we've come together and support House Bill 1247 and worked with Representative Conley and some other advocates around this bill because for us, and this is a notice bill, and notice for us equals housing stability. As has been noted by several other speakers this morning, we have a supply side problem in New Hampshire. According to the residential rental cost survey, our statewide vacancy rate in the rental housing market is very, very low. We're at 0.75% statewide and at 0.3% near the job centers. Many landlords in our state have already instituted fair and functional practices. So we know members of Housing Action New Hampshire who are already giving this kind of notice to tenants before they need to implement rent increases. However, this is a matter of policy, and this is about protecting those who are falling through the cracks and ending up at the welfare offices seeking support to be able to stay housed. And keep in mind that any increase 4.9% and under doesn't require any additional notice. With that, I'll conclude my remarks and save the rest for speaking to the amendment. Thank you.
Thank you.
Thank you.
I do not see any questions. Okay, and that was our last speaker, Senator Hennessy, for the bill.
Thank you very much, Tricia. So we are going to now close the hearing on House Bill 1247. And I'd like to just remind everybody that ED&A committee has a meeting at 1 p.m. and they can't start their business until we finish ours. So we are going to try to work as quickly as we can, and again, to control the length of people's testimony, although I hope everyone knows how much we value your testimony. I'd like to open the hearing now on the amendment 1363 S and call Senator Feltus to introduce 1363.
Thank you very much, Madam Chair, members of Senate Judiciary. Good morning. It's great to be before your committee once again, although virtually. Thank you for listening to this testimony this morning and considering this amendment. So what's going on? Well, we have a moratorium right now on evictions for non-payment of rent. We have a moratorium right now on foreclosures of homeowners. That moratorium began on March 17 under the Governor's Executive Order 2020-04, and it will expire with the state of emergency when the state of emergency is lifted. We don't know when that's going to be, but for 3 months approximately, there's been a moratorium on evictions for non-payment of rent and a moratorium on foreclosures, flat out moratorium. So the question becomes, what happens when those moratoriums are lifted? What happens? Do we protect people in any way, shape, or form? Or do we do nothing? So I gotta say, on the one end of the spectrum, there are folks that have argued for an extension, flat out extension of the moratoriums for several months with mandated loan modification, principal reduction, all kinds of different arguments on the one end of the scale. And then on the other end of the scale, which you'll probably hear a good amount of testimony here today, is do nothing. Honestly, I don't think either approach is reasonable. What this amendment tries to do, is strike a balance between those two wildly divergent positions about what happens when these moratoriums are lifted. And I think, in my view, Madam Chair, it's a reasonable balance. So let me go through why I think that this provides a reasonable balance and a glide path to protect homeowners and renters. And by the way, protect our housing market. Let me just put a pin on this, because if we lift these moratoriums and our housing market somehow gets destabilized with a rush of evictions for non-payment of rent, a rush of foreclosure, this housing market, as you have heard this morning, is already not in good standing. Do we want to risk the housing market being completely destabilized? Well, if you're arguing to do nothing after these moratoriums are lifted, you're basically arguing to risk destabilizing the housing market. I don't think that's reasonable. That doesn't help anybody. So let's look at the amendment proper and go through it as quickly as I can, Madam Chair. I know there's a number of people who want to testify. Starting with section 2 on page 165 of the calendar. Section 2 says that eviction notices are not required in order to get rental assistance from municipal welfare. Just generally forcing the issuance of an eviction notice doesn't really, it's not very productive for anybody in order to get some help. So that's the purpose of this provision. However, I know that Patricia Murphy from the town of Merrimack is going to provide some testimony and an edit to this to say that if there is some other programming that requires the issuance of an eviction notice and you're coordinating through the municipal welfare office, then fine, that would be an exception. But I think I saw the language that she's going to suggest, and it's reasonable. It's a reasonable edit to section 2. let me bounce down to section 4. Section 4 deals with making sure that rooming and boarding houses are captured within our eviction law. What we saw coming out of this executive order on March 17 is the coverage did not extend for protections for folks in rooming and boarding houses. It's time to actually provide protection for folks in rooming and boarding houses in terms of evictions, and just go through the process for that. So let me deal with now the bigger issues. Why don't we talk about section 5? Here is the 2 basic provisions in section 5. Section 5, paragraph 3, talks about what should happen in the 6-month period following the end of the state of emergency. And basically it says not increasing a tenant's rent by the pro rata share of the increase in property taxes and the utilities, and basically saying, all right, you know what, we know we're all in this together, but let's not ramp it up and sort of price gouge potentially in the 6-month period following the state of emergency. That's what that goes to. Another different but substantive and very important provision is section 4, paragraph 4. Basically, it says unpaid rent during the time of the state of emergency. Try to work out a deal for the arrearage, the unpaid rent, and partial payments over a 6-month period. So in other words, there's unpaid rent. Try to work maybe in this 3 months time frame. Do a deal for a 6-month repayment of that unpaid rent. Now, again, most landlords are working with people, no doubt. This deals with, quite frankly, the situation where a landlord refuses to work with someone. And we have heard, you've just heard about it, that the unemployment benefits are going to drop effective July 31st. So we got a perfect storm of a moratorium on evictions for non-payment of rent being lifted and unemployment insurance benefits dropping for people who have been crushed by job loss. All this says is work with folks to pay that off over a 6-month time frame. That is more than reasonable. Now bumping up to the foreclosure provision. The basic provision is on page 166 of the calendar, paragraph 6. And before I go into the details of this, let me just say, the banks in New Hampshire and our community banks in particular have bent over backwards for homeowners and for businesses during COVID-19. There's no doubt about that. There's no dispute about that. And everybody is grateful for all of the work they have done, including working with the PPP program to help our businesses. And our banks here, community banks in particular, have done a number of forms of forbearances and have done, in some cases, loan modifications. This provision in no way overrides those existing agreements, and nor is it intended to override those existing agreements, nor is it intended to say that this is a one-size-fits-all dealing with forbearance. In fact, if you look at the actual language, it says, in the absence of an agreement between the parties for a different form of forbearance. In other words, you can make whatever agreement you want, but all it does is set a baseline right that all interest and fees that were accumulated during the time of the state of emergency could, at the option of the borrower, be paid at the end of the mortgage, provided that such payment don't exceed the principal and interest at the time of the state of emergency was declared. In other words, only interest and fees, not even principal. I got to tell you, a lot of other states are pursuing a forbearance type legislation that includes principal too. So this is a really baseline, really basic protection that says at least the interest and fees could be paid at the end of the existing mortgage in a form of forbearance. So borrowers have at least a baseline right to that before they get foreclosed on, before they lose their home. And folks, we have, Madam Chair, members of the committee, we're operating in a non-judicial foreclosure state. In other words, we're in the minority nationwide where, largely speaking, banks do not have to go to court to remove someone from their home. So to me, I think this is a very baseline protection that says interest and fees you have a baseline right to interest and fees at the end of the mortgage. Again, nothing here overrides these agreements that have already been made or any agreements that could be made down the road. And to be clear, most banks, especially our community banks, are operating in good faith with homeowners right now. And so I'm sure you'll hear a lot of testimony in opposition to this, but let me tell you, this is a baseline right. It's not where a lot of folks would want it, but my belief doing nothing after this moratorium is lifted is not an option. And I know that you'll hear lots of testimony about how banks are working with folks in good faith. The committee might want to entertain an amendment that just solidifies that good faith negotiation. But the upshot is, in my view, doing nothing is not an option here. And again, most banks, especially our community banks, are working with folks, but I don't think we can afford to leave this session without providing some modest protections for homeowners. No one can afford that, in my view. So with that, Madam Chair, I'd be happy to answer any questions. I really appreciate the committee listening and appreciate the committee's time.
Thank you, Senator Feltes. Are there questions for Senator Feltes?
Senator LeBake.
Thank you, Madam Chair, and thank you, Senator Feltes, for your testimony. With the last section that you talked about, are we in any way absolving people from paying their mortgages?
No, all it says, Senator LeBake, is the interest and fees that were accumulated during the state of emergency at the option of the borrower could be paid at the end of the mortgage with some additional monthly payments, provided those monthly payments don't exceed the monthly principal and interest payments already existing during the state of the emergency. So we're not absolving anyone of any debt. That's been something that has been proposed in other states. That's not in this. This is, in my view, a very baseline protection and right, a very modest protection.
Thank you.
Okay. I do not see any questions on my end, Senator Hennessy.
Okay, thank you. So we'll go on to those who wish to speak.
Okay. Okay, well, I will start calling on those that wish to speak to the amendment, and I will just remind those there will be timed for 3 minutes. And Ava or one of the other staff will let you know when that is up. The first speaker we have is, let's see if she's, or, no, okay. So we're going to go on to the next person. We have Elliot Berry. Mr. Berry, if you are calling in, could you please dial *9 so your hand will be raised? Okay, thank you. Okay,
Thank you. Can you hear me okay?
Yes, thank you.
Okay, thank you. And again, for the record, I'm Elliot Berry from New Hampshire Legal Assistance. I just want to emphasize a few things that about specific parts of the bill. Part 2 of the bill about local welfare, I just want to clarify a little bit that very often when people go to municipal welfare offices because there's nowhere to go and they can't pay their rent, the office will send them back if they don't have an eviction notice yet. but that works terribly because it extends the time that the tenant's behind. It really destroys relationships between landlords and tenants. And tenants only have a right to a notice to quit, to cure an eviction notice 3 times within a 12-month period. After that, even if they pay during the 7-day cure period, they can't avoid the eviction. Also, sometimes when they're sent back because they don't have the eviction notice yet, they come back to the local welfare office and they're told we don't pay arrearages. So the problem is it's problematic, and what we want to do is make sure that when the need arises, the tenant can get and the landlord can get the rent paid close to on time. We have absolutely no problem with the amendment that Patricia Murphy is offering to make sure that eviction notices can be used to prioritize their attention and for the other purposes in her proposal. Part 4 about rooming houses is really, really important. And let me just give you a quick history. It used to be that it said if an occupant of a rooming house becomes a tenant when they after 90 consecutive days in the facility. So what many owners did is they would make them change rooms after 89 days. Then the legislature changed that so that the 90 consecutive days applies to any room in the rooming house. So if you went from one room to another, it didn't break your 90 consecutive days to become a tenant. So the next thing they're doing now is many rooming house people are making the tenant or the occupant leave on the 89th day for one night, so they don't attain the status of a tenant. You have very, very poor people living in these places. They have no other residence. The idea of the exception is based on an outmoded perception that this is transient housing, and if the occupant has no other principal resident, it is really important that they be treated as any other tenant and be entitled to tenants' rights, including an eviction process. Section 5 of the lease, again, no late fees assessed for late payment during the COVID period as just simple fairness. I'm sure controversial is the limitation on rent increases, but note that they can landlord during.
Interrupt, but the 3 minutes is up.
Okay. Thank you.
Thank you. Do we see any questions for Mr. Berry?
I do not see any. Okay. We will go on to the next speaker. Okay. And if Sue Chang has joined the meeting, you are on the list. If you are calling in, if you could just dial *9, your hand will raise and I will call on you when I see that hand. Thank you. Our next speaker is Christine Morin. Miss Morin, you should be able to speak now. Go ahead.
Well, good morning.
Good morning.
Thank you very much. Madam Chair and honorable members of the Senate Judiciary Committee, I am Christine Morin. I'm Chief Risk and Loan Operations Officer at Mascoma Bank. I've been there for 32 years and been in the industry for 40, so kind of been through some of these cycles, but certainly not like what we're going through now. But thank you very much for the opportunity to share my thoughts on the proposed amendment. I certainly appreciate the senators' recognition on the work that the banks are doing all over the state and helping our customers navigate through all of these kind of uncharted waters. I want to talk a little bit specifically about Section 7 and under 479.25A and I'm sorry, yes, not Section 7, sorry. Section 3 under that section, and specifically speaking to what we're already required to do. So under Dodd-Frank, we are required to ensure early intervention and to inform our borrowers of any type of available loss mitigation options. So we're already required to do that. We have to attempt to establish live contact by day 36. We send written communication to our customers at 30 days, at 45 days, and at 60 days. And in all of those correspondence or communications, we have specific information on loss mitigation options, all of those options. So when I look at number 3, A, C, and D, we already do that. That's part of Dodd-Frank, and we have to do that. Item B, we do much more than that. It's more than highlighting one item in the absence of an agreement. It really talks to the broader and all of the specifics that we are required to do to inform our customers of loss mitigation. So we think, we do a lot of that already. If I go then to the section that speaks about some of our other practices, I think that that we could have some unintended consequences as we try to implement some of those. So what I think about are operational issues or even potential confusion with our customers. So I went kind of number 1. We are always willing and needing to have some type of an agreement with our customers. So whether it's informal or formal, there's always going to be some type of an agreement as to how we proceed and what that looks like. 2, if we extend the loan term, we're going to need to modify those agreements. If we're modifying agreements, we need a signature. We're not going to be absent a signature or a document. And then the other thing I think of is that not all loans are fixed rates. We have adjustable rate loans as well in our portfolio, and those payments will change. So, we think about going back to a prior payment in a different.
So sorry to interrupt, but the 3 minutes is up.
Oh, gosh. Okay. I'm sorry. Well, thank you for your time. I appreciate it. I'm happy to answer any questions if you have any questions.
Yes, Senator Chanley, go ahead.
Good morning.
Thank you. Good morning, and thank you, Ms. Morin. I have a question. First, I don't know, can you answer this? I don't know if you have this answer, but I'm just wondering what you're seeing in New Hampshire regarding delinquencies and over the past several months, let's say, since the beginning of the year.
So
trend.
Well, I can tell you what's happening in our institution. If I pull out the New Hampshire customers that we have done mortgage forbearances for, we've done 132 mortgage forbearance kind of documentations for our customers in New Hampshire. Now that can be anything from interest only, interest in escrow, escrow only. It can be a full out modification. We've just done, anything that works for that particular customer to help them. So 132, it represents in the numbers, about 3.5% of our portfolio. So again, very manageable numbers. We have the expertise and the infrastructure to be able to work with our customers. And with those numbers, they are certainly very manageable numbers.
And if I might follow up, you did talk a little bit, you answered part of my question about how this proposed legislation relates to any federal legislation that you operate under. I don't know if, is there anything more you'd like to add to that, either with regard to the CARES Act or any other kind of federal guidance?
No, well, I think, I would add that certainly the CARES Act does play into this. But even absent the CARES Act, I think all of us as community banks and community bankers do what we can to help our customers through this, whether it's this or it's something that happened 10 years ago, whatever it might be. Our intention is never to foreclose on folks. That's always a last resort. And I think if you look at the numbers, the community banks do that very seldomly because it's just not who we are. And so I think, we already have so many things in place that help us with all of this. It just seems like it's just one more thing to kind of potentially confuse the customer on what's this document and what's this document for.
Thank you very much.
Okay, Senator LeVake.
Good morning. Oops, I can't hear you.
There you go.
Thank you, Madam Chair, and thank you, Ms. Morin, for your testimony. I do want to say that it sounds like your banks are incorporating some best practices that we should be adopting. And I have a question on a couple things that you said about unintended consequences, and you mentioned signatures and fixed rates. Could you help me understand what you meant?
Well, the proposal speaks to not having an agreement. It says absent of an agreement in place. So where I'm going with that is that we're always going to have an agreement. We're going to have something, again, whether it's informal or formal. And if we need to modify a loan and the terms of that loan, and we're adding payments to the end of a note, and we need to secure that mortgage, then we will need a signature. So I don't feel that we're ever absent a signature and then needing something to be put in place. Adjustable rate loans, so those are loans that are not fixed, that are tied to an index, and those payments change throughout the time of the loan. And if you're talking about a 30-year loan that we're now adding something to the end of that, and that's an adjustable rate, it's hard to even know what that rate could be 20 years down the road, or the payment amount 20 years down the road. And then to try to back into something that happened many years previously with what that old payment amount was, because that's the amendment speaks to the payment needs to revert back to the payment at the time of this emergency. And so how do we do that? Yes, we can, but operationally that's difficult. And then how, what does the customer know? What if their payments went down and didn't go up as the loan progresses? And now at the end of the loan, their payment goes up. So it just, I think, can be confusing for everyone.
Follow up. On the second part of your question or your response, can't we calculate the interest that was not paid and then tack that specific amount onto the back end of a loan? I'm not a mathematician, but it seems like there's a way that you can work this out. And we're talking about a short period of time in the life of a loan,
right,
to transfer that amount onto the end of a loan.
Right. And we're already doing that for customers.
And see, best practice.
That's what I'm saying. We're already doing that. But we're doing that without the constraints of a certain way to do it. It's just when it works, we're doing that.
Okay. Thank you.
You're welcome.
Okay, Senator French.
Hello.
Hi. There you go, Senator French.
Thank you. And question for Ms. Morin would be, how many of these 132 loan modifications you made have been directly related to the COVID crisis?
To COVID-19? All of these.
All of the 132?
Yes. Yes, we started collecting that information kind of on day one when we started to offer the modifications or any type of forbearance to the customers. So again, initially, the first couple of weeks into this, it was probably more customers asking just to make an interest-only payment. Not sure what the next few weeks are going to bring us or the next month. Could I just make interest only, or can I just pay my escrow this month? So we started collecting that data early on. Again, some of the, I've been in the industry for a long time, so I know that we'd need to have some of these metrics behind us and be able to trend and track things as they go along. So we put things in place immediately to start tracking. So these are all COVID related, and these are in New Hampshire. I mean, we have loans in Vermont as well, but this is the New Hampshire base.
Okay, thank you.
You're welcome.
Okay. I do not see any more questions, Senator Hennessy.
Great. So thank you, Ms. Morin, and
Thank
for your
you.
best practices.
I appreciate your time. Thank you very much.
Okay, so we will go on to our next speaker, who is Ryan Pope. And I will pull, and we have 13 speakers left. Here we go. Oh, okay. I'm sorry. Ryan, Mr. Pope, are you there?
It appears, Trisha, he's been no longer on the attendees list, so maybe if he's calling in.
Oh, no, you know what? He had an older version of the of Zoom, so it said it had to move him. Okay. We will go on. Mr. Pope, if you can hear me, if you could dial back in or get back on, I will call on you. The next we have Christy Merrill. Hello, Christy. You can speak now.
Hi, good morning. Thank you, Madam Chair and honorable members of the Senate Judiciary Committee. My name is Christy Merrill, and I'm president of the New Hampshire Bankers Association. The New Hampshire Bankers represents 38 members, which employ nearly 6,000 employees. Thank you for allowing us to testify today via this format. I know it's a little bit different. So I appreciate the comments that Senator Feltus made about some of the things that banks are doing, and Christine Morin's testimony as well. I think those are really important points. You know, before banks were required to do so by the federal government, as soon as this pandemic hit, banks really stepped up to try to help business owners and community in their communities in all sorts of ways. And that was through offering forbearance. They are supportive of forbearance. And they've also just tried to help in a whole host of other ways. So actually, I just want to state that we are in opposition to this amendment, and my comments are focused on primarily on section 3, 6, 7, and 8. We're not commenting on the underlying bill or on the sections that are dealing with the pieces for rent. You should have received my testimony as well as a survey that we conducted. Once the CARES Act was passed, we wanted to understand what type of forbearance our banks were offering. So in the information that you should have, we had a small amount of time to get responses. We had 24 hours, and we were able to get 20 responses in less than 24 hours from 38 of our member banks. Every single one of them were offering forbearance to their customers. And you know, those banks were really doing that in a way that was made sense for their customers. So that could start with 3 months forbearance. As Christine said, it could have been interest only, or you know, interest and escrow payments only, so they don't get behind on their tax payments. It was really based upon what was helpful for them. It's important to note that this is being done by small banks and large banks. So this is not just a community bank thing. This is something that all of our banks in New Hampshire are doing, because they really believe that they want to help people that are having financial hardships right now. And so our concern with the amendment is that this could impact what the banks are offering. We're concerned that it could adversely impact the customer by having a little bit less flexibility. While some banks are already offering to move the payments to the back of the loan, there may be other options as well. And Senator Feltus is right. He did improve the language and added language that talks about in the absence of an agreement, and we appreciate that. We do think it makes it better. However, we still do believe that there could be some less flexibility for both the customer and the bank. And so that is a concern of ours. Another concern is, unlike the Federal CARES Act, there is no attestation for hardship in this. So That's a concern of ours. There are also several drafting concerns that we have, which I can get into if there are
I'm so sorry to
questions.
Interrupt. The 3 minutes is up. I apologize.
Thank you. I'm happy to answer any questions as well. And I also have data. I know some of the senators have inquired about forbearance rates. I have that type of data as well.
Okay.
Senator Chandler.
So I guess, and I don't have the survey in front of me. Thank you so much, Ms. Merrill. Are your banks averaging about that 3.5%? Do you have that in your survey? Is it about that 3.5% who are looking for forbearance?
Sure. Yeah. So we did a separate survey to try to get a scale and the scope of what the modified payments are like via forbearance in some way. And basically what we found is we got 31 responses from our banks and the average was about 2%. And so I think what's important to know about that is nationally, those numbers are more like 8.3%.
And related to, I guess it's similar to the question I asked Ms. Morin, and that is just how would this amendment affect folks in New Hampshire in a way that, with regard to the other federal regulation, federal guidance, other, where do you see, how do you see this piece of legislation affecting everything, all of the other regulation of the industry?
I think that, Section 3 of the bill, particularly in paragraph starting with Roman 7, addresses that. So I don't really have those concerns, but I will say there are a couple of federal agencies that were left out. There is no reference to the Federal Home Loan Bank, and there's also no reference to VA loans as well.
Okay, thank you so much.
You're welcome.
Senator LeBake, are you asking? I want to ask one after you.
I'm going to say, Madam Chair, you can go first.
Oh, thank you. I have just a quick question right now. One is, you said there were 31 responses to your survey, and I'm wondering out of how many was it the survey sent to?
Sure. So we've had two different surveys. One was to get a sense of how many banks were offering forbearance. And of that particular survey that went to all 38 of our members, we got 20 responses in less than 24 hours. We just had a shorter window to work with, and all 20 of those offered forbearance. On the second survey, we were trying to get a sense of the scale of the amount of mortgages that were in forbearance, because we are also concerned about foreclosures. And of those, that went to all 38 banks, and we got responses from 30. But I will say that due to some of the nature of some of the banks, some of them are regional banks, they can't always pull out New Hampshire specific data. And so that's where we get the average 2% number. And that's only our member banks. It does not include credit unions. It doesn't include the mortgage bankers and brokers, but those are our members.
Thank you.
You're welcome.
Go ahead, Senator LeBake.
Yes, thank you. Thank you, Madam Chair. Thank you, Ms. Nolivo. Okay, thank you, Ms. Merrill, for your testimony. You talked about having less flexibility. Could you elaborate on what you mean by less flexibility?
Yeah, so the forbearance survey results which you guys have, or you should have, it shows the different ways that banks are providing forbearance to their customers. It might be for 1 month, it might be for 2 months, it might be 3, they may extend it for another 3, it might be interest only, interest and escrow only. Some do skip payments entirely. So I think what is happening in this amendment is it's basically saying it's got to be put on the back of the loan. And that is happening in a lot of cases, but it may not provide some other options if they wanted to do a refinance altogether. If the numbers don't work for the bank, they may not be likely to offer that option. So I think as a concern that we would have is by saying that it would be done this way, it could just result in a few other options that customers might otherwise have on the table.
Follow up
Oh,
on section, let's see, section 3B, it does say the borrower's right. The mortgage lender shall send written notice of the borrower's right to make additional monthly payments at the end of the mortgage term. So they have the right to, but they don't necessarily have to take that and should be open to other options. In that regard, would you say that it's more flexible if other options are offered to the consumer, the borrower?
I do think it addresses that issue in part. We would want to work with legal to get that right. In sharing this with our members and with legal, I think there is still a concern that it would impact flexibility. And I'm glad you brought up the issue, Senator, of the right. This language is also not clear to us whether or not customers have a right to be notified of forbearance, or if the lender is required to grant the forbearance. And so that's another point of clarification that we would be looking for if this moves forward.
Okay, thank you.
Thank you.
thank you, Christy. And I just have one other question. What I'm hearing sounds like, and I'm going to make an assumption, and please correct me if I'm wrong, but I'm assuming that the Bankers Association would not necessarily want us to do nothing on these issues, but that you have some requests for additional or changed language. Is that true?
Senator, we are always happy to have conversations with you all on how to improve the legislation. We don't feel that this amendment is necessary. And so I guess I would respectfully disagree that, we're not looking to do nothing. I would say that banks are working very hard to support homeowners in their time of financial difficulties right now.
Okay.
And it truly is a loss for everyone when there's a foreclosure, and banks are working very hard to avoid that.
Thank you.
Okay. I do not see any other questions. All right, we'll go on to the next speaker. We have Kurt Strandson. Mr. Strandson, you should be all set to speak.
Can you hear me?
Yes.
Thank you, Madam Chair and Committee, for allowing me to speak this afternoon. My name is Kurt Stranson, for the record, and I'm speaking on behalf of the Mortgage Bankers and Brokers Association of New Hampshire. I first want to state that we are, very sensitive to Senator Feltz's comments and concerns, and purpose and reason behind bringing the amendment in Section 3 regarding foreclosures and forbearance. I do not want to waste time repeating a lot of the points that was previously made by Ms. Merrill, but I do also want to add that the Federal CARES Act provides robust assistance to borrowers who have a federally regulated mortgage that is flexible and sustainable, forbearance upon request for up to 12 months, waiving of assessments of penalties and late fees, loan modification options at lower payments or keep the payments the same after the full forbearance period is already part of the Federal CARES Act. In addition, on May 13th of 2020, FHFA, which is the Federal Housing Finance Authority, announced a new payment deferral option that will be available for GSE-backed loans, which is Fannie and Freddie-backed loans. This option is detailed in a Fannie Mae lender letter and a Freddie Mac bulletin, which will allow borrowers exiting COVID-19 related forbearance to resume their prior monthly payments while deferring repayment of the foreborne amounts until the home is sold, refinanced, or reaches maturity. Our concern in opposition to the amendment is that the Federal CARES Act goes to great lengths to accommodate many of the concerns that were raised in the amendment in general. And our concern is that if our state legislature passes a law that is in conflict with what the federal regulators have, then this may cause this issue to be ending up in the court system, which could further increase the cost of mortgages to other borrowers and homeowners and tie up this issue when in the original intent is to help people. We have a lot of the same comments and feelings as previously testified by Ms. Morin and Ms. Merrill. With that, I'll open it up to any questions.
Thank you, Madam Chair. Thank you, Mr. Stranson, for your testimony. You mentioned all of the offerings that are provided in the CARES Act. Do you and do the banks ensure that all borrowers are aware of all of these options available to them?
That's a great question, Senator. I think where that can be best done is the 3.6 million that was allocated to New Hampshire housing through the stimulus money from the CARES Act. I think one of the two major components of that is education. And previously, during the foreclosure crisis years back, New Hampshire had New Hampshire Home Help 211, which was a call-in number to help borrowers with questions that needed assistance. And I know a lot was done through all of the nonprofit housing agencies in New Hampshire as well. When we look back upon the prior foreclosure crisis, New Hampshire had a very high success rate with Home Help New Hampshire, which I believe over 70% of people that called in and asked for assistance had some sort of positive outcome, where other states didn't have nearly as good of results.
Follow up. Thank you for that answer, Mr. Stranson. I'm more curious as to whether the banks themselves offer this information before you start foreclosure or working out other remedies. Do you point people to the CARES Act?
So the federal insured mortgages, I have some statistics that can speak to some of that. This is coming from our national organization. The average speed to answer consumer calls decreased relative to the prior week from 1.6 minutes to 1.3 minutes reported on June 1st. And call abandonment rates decreased from 4.6 to 4% on June 1st. I think where they're going to get that information is when they get their mortgage statement and they have their servicer's contact information right on their statement, and they call in and ask for assistance. The statistics are showing they're being responded to exceptionally fast. I mean, 1.6 to 1.3 minutes. I sat on hold with Comcast for 4 minutes on certain days. I mean, that's exceptionally fast. But I think that as previously testified, everybody's circumstances is different. There's not a one size fit all to people's circumstances, what they're looking for and what they need to do. And the Federal CARES Act is very broad in offering, as it says, up to 12 months forbearance. I know our stay-at-home orders are being lifted shortly, but they have up to 12 months that is given from the Federal CARES Act. And the loan modification opt-ins, that the lower payments keep payments the same after the forbearance period. And the option provided is, as Ms. Merrill previously stated, a much more flexible bucket of options for people rather than having our state say this is what you have to do in this fashion.
Follow up.
Okay,
thank you for your statistics on response time. My question is, are the borrowers being given the information on the CARES Act? So that's what I didn't hear from your testimony.
Are the borrowers receiving,
information on how they can defer their mortgages or get relief somehow through the CARES Act? Is that something that the banks are sharing with their customers?
I would believe that they would get that information when they call into the person who's servicing their mortgage and they ask for that assistance.
Okay, thank you.
Okay.
Other questions?
I do not see any here. Okay. Okay, and we have Ryan Pope back on the line. Mr. Pope, you should be able to speak now.
Good morning. Sorry about that.
That's okay.
Yes, my name is Ryan Pope. I am Vice President and Office Manager at Cambridge Trust, located in Stratham, New Hampshire. I want to start by saying that bankers are united behind Senator Feltes in the spirit of the amendment. And it's in that spirit that our industry has worked to provide customized forbearance terms to our clients and customers in order to provide necessary financial relief and avoid foreclosure. The amendment is written, though, namely its baseline terms laid out in paragraph 6, raise several questions with regard to the servicing of the loans under forbearance. The amendment does not make clear how a borrower and lender are supposed to deal with monthly tax and insurance escrow collection during the forbearance period. If the lender is to continue making tax and premium payments on the customer's behalf, it doesn't seem like those costs could be recouped because the payments due at the end of the loan can't exceed the monthly principal and interest of the payments during the forbearance period. And it's also not entirely clear what the expectations are for municipalities and insurance companies that are supposed to be receiving those payments. Additionally, the mechanics and accounting behind the additional monthly payments added to the end of the existing mortgage presented some issues. Given that payments can't exceed the principal and interest due during the forbearance period, what ends up happening is lenders have to account for that kind of off the books so as not to interfere with the interest calculations that result by extending a loan term. What we learned while we crafted our own program is that our loan systems aren't programmed to both extend term and delay interest calculation at the same time. There's also some concern about the possible length of time of the term of forbearance in this language. Many banks have been setting terms at 3 and 6 month intervals, which can be extended on a needs-based basis. The language in the proposed amendment appears to set a term effective from March 13th, expiring 9 months after the end of the state of emergency and any extensions thereof. We're still in the midst of this global pandemic, and if the state of emergency is extended because of continued outbreaks, it could result in forbearance terms that extend well beyond what is actually in a borrower's best interest. During the forbearance period, there's obviously no reduction of loan principal. And for highly leveraged properties, that could create the unintended consequence of borrowers owing more on their home than it's worth, which would disparately impact many first-time homeowners who obtain financing with little to no down payment. If the property values are to decline or did decline, many of those homeowners would find themselves in an upside-down mortgage, leaving them in a position where they cannot sell their home without incurring financial losses. Thank you.
Okay. I do not see any questions on my end, Senator.
Okay, thank you.
Thank you. Okay.
Thank you, Mr. Pope.
Next, we have Matt Menning. Mr. Menning, you should be all set to speak.
Hi, can you hear me okay?
Yes.
Thank you again to the committee and for your time. I'll try to keep it brief. There's been a lot said. We don't have as much kind of knowledge around the mortgage provisions. Again, introduced ourselves earlier. We're property management and rental property owner, about 1,500 apartments in New Hampshire. I'll try to say something different that hasn't really been talked about. And that's kind of the overall economic implications of these types of policies. This creates in my estimation, a deferral of payments, and it has a kind of exponential effect as those payments get deferred. So where the customer, the apartment resident, is deferring payments to the landlord, and then there's contemplations of the landlord deferring payments to the bank, maybe deferring payments to their insurance company or for their tax bill. You kind of destroy the velocity of money in the economic system. And when one bill doesn't get paid, then the person who works at the bank, now what are they deferring? The person that works for the town and provides services for clearing the streets and snow plowing, what do they do? So it kind of crunches everyone's budgets, and all those, that $1 of rent turns into many, many dollars of income for many people throughout the economy. So the kind of change in the conversation, and I'm not sure if this is something that rests with the legislature at this point or with the governor's office. I'm not knowledgeable enough about the way that the system works, but it seems to me that stimulus through assistance for people who are having trouble paying rent due to COVID is a superior economic policy, because then the rent bill gets paid, the mortgage bill gets paid, the tax bill gets paid, the maintenance bill gets paid. Those people receive that income, they pay their bills, and so on and so forth. I wonder if this type of legislation shouldn't be envisioned with a rental assistance program, maybe similar to the federal unemployment. I don't know what we can do at a state level, and so I apologize, I don't have the answers, but I think maybe to change the conversation on this particular bill, I think there's a better outcome when instead of deferring bills, we're helping people pay bills. That's about all I have to say on it. I'm sure others will speak on all the details, but I thank you again for your time and welcome any questions.
Okay. I don't see any questions here.
Mr. Mending?
Thank
Yes.
you. Thank you for your testimony.
Thank you.
Okay, our next speaker is Stephen Bauer. Mr. Bauer, you should be all set to
Yes,
talk.
good morning, Madam Chair and members of the committee. I'm representing Mortgage Bankers and Brokers Association of New Hampshire as well as Kurt. And I had submitted written testimony yesterday, so hopefully you have that. Our testimony is kind of technical on how the bill was drafted and some of the concerns that we have. You can, in Articles 5, 7, and 6. And the other half of the testimony listed federal agencies that, in my mind, have been really out front trying to protect the people as we go through this COVID and offering forbearance, changes to their normal way of practicing business and such. So there's the HFFA extended the foreclosure and eviction moratorium, the CFPB, the HSFA and HUD has put together a joint website. They're really advertising and promoting their information to the consumers via social media, and also I know that Mortgage Bankers has all this information with links off our website. I'm sure that anytime you call a servicer, you're giving this information. So I just want to let people know that there are things happening out front, and to not pass this legislation is to do nothing, because there are already things being done at the federal level, which brings up the point of, if New Hampshire tries to do something that's in conflict with the federal level, does that create further conflict for the consumer and trying to benefit their situation? So for those reasons and all the reasons that Kurt came up with, and Christy and Christine, we're in opposition to the bill, and thank you for your time.
Senator LeVake?
Thank you, Madam Chair. Thank you, Mr. Bauer, for your testimony. Can you elaborate more on the conflict with the federal level?
I didn't hear your full question, I'm sorry.
Could you elaborate more on the conflict with the federal level?
It becomes into the legal issues that have come up earlier. It's where the GSEs underwrite a loan to a certain way. And for New Hampshire to come in and say, no, we're changing our rules for our state, then that comes into conflict with how those loans were originally written. So the GSEs over the last couple of months have really been coming around and trying to loosen guidelines up and to make changes for their mortgages. And so it's difficult for a state to step in and say, we're going to change how that mortgage is serviced. We came up with this when we talked about it in the foreclosure commissions for the last number of years. And it's, federal leads the way, and it's difficult for New Hampshire to come in and change something because then people don't want to actually do business here either.
Follow up, please. Thank you for your response. Can you tell me what is GSC?
Oh, that's your Fannie, Freddie, your
Federal
government,
lenders?
your government secured, your government backed mortgage providers, which this bill doesn't cover all of them as well. And we're kind of just trying to figure out if we already have, if all of the federal loans are covered by those rules already, what really does this carve out look at? Is it just the private mortgages? So there were some issues with the way the bill was written, or the amendment.
Mr. Bauer, are the federal loans administered by local banks or different banks?
Well, I'll answer it this way because I'm not sure how that it's really administered. They underwrite their loans to their guidelines, and then most of the time the loans are sold to Fannie, Freddie, Ginnie, and then service from that.
Last final follow-up, just for my clarification and understanding, can I go to like a DCU and get a federal backed loan?
Yes, definitely.
Okay. So DCU is administering that loan, correct?
Correct.
Thank you. Thank you very much.
If I'd like to ask a quick question of Mr. Bauer. So it sounded in the beginning of your testimony as though you were saying that there were technical difficulties within the amendment as to how it was drafted. So that language makes me think that perhaps there are ways for the language to be amended. And I'm wondering if you, and I should have asked others, would be interested in sharing those ideas for a way to amend the amendment.
Myself, I'm not a legal expert in servicing and all the guidelines that this bill tends to touch to. I don't know if it's really worth the effort. Certainly, if you wanted to go forward, the association would look at any requests.
Thank you.
Okay. We will continue with our next speaker. Okay, that is Elisa Margolin, who is calling in. Excuse me while I find her. Oh, there she is. Okay, Ms. Margolin, you should be able to speak now.
Thank you. Good morning, Madam Chair, members of the committee. Alyssa Margolin, I serve as Director of Housing Action New Hampshire. I'm not going to speak to the mortgage forbearance portion of the amendment. Rather, I'd like to focus our comments on what we support within the amendment that's connected to our education and advocacy related to the anticipated evictions crisis in New Hampshire and around the country. Unfortunately, we have created or find ourselves in a perfect storm for a very concerning eviction crisis. As I noted earlier, and as many of the speakers noted, we have a very cost-burdened renter population because of the lack of supply of affordable rental housing in our state. In fact, just under or close to 50% of New Hampshire's renters are cost-burdened, meaning they're paying too much of their monthly income towards rental costs, and that's been going up every year as costs have gone up. So it's considered that 30% of your monthly income should go towards housing costs. Those folks are paying over 50%, and in many cases, quite a large percentage of their income. This situation, coupled with COVID pandemic-related job loss, and then also connected to the soon ending bonus to unemployment benefits, and also arrearages that have been happening during the eviction moratorium that was very much related to needed to enforce the stay-at-home order and to make sure we had good public health protocols during the pandemic. So we are anticipating a very concerning eviction crisis. We have been advocating with the Governor's Office for Emergency Relief and Recovery for a comprehensive rental stabilization program. I think as one of the speakers noted earlier, how important this would be to stabilizing our rental housing. The amendment before you today does note that eviction notices should not be required, and this would be very important to smoothly rolling out any kind of program if it's created with those CARES Act monies. Right now, this very small amount of eviction prevention dollars that we have in our state do require these eviction notices, and this has created some administrative barriers to actually accessing the resources that you allocated last session. It seemed to make sense with good stewardship that you should have to prove that you were facing eviction before you asked for that. But when we put the moratorium on evictions, those notices weren't being generated. In addition, the courts were closed. So we need to find other ways of identifying the inability to pay rent, but not require the formality of an evictions notice. So that's an important piece of the amendment before you. And I would say the other piece is that the reality is that rooming houses for many folks have become their primary residence, and it is time to protect those folks as well, and to tenant protection. And that concludes my remarks, and I'm happy to take any questions.
Okay. Senator Chanley.
Thank you, and thank you, Ms. Margolin. I have a question, and it might be a little bit unfair. You may not have this information in front of you, but I've been doing like different back of the envelope calculations throughout this whole discussion. And I'm just wondering, do you know what, on average, the cost to a renter is to move? Let's say a renter who's paying an average New Hampshire 2-bedroom rental. Do you have any idea what the cost to move is?
So Senator Chanley, I don't know that we have the data on the typical financial cost of moving is. I know that for extremely low income families in our state, frequent moving or unstable housing is a real issue for children or for families who are experience frequent housing instability. So for example, they might find themselves in a winter rental and then move their kids to a different school district, when, towards the beginning of the summer season. And, but I don't know the financial cost to having to relocate.
All right, thank you, thanks.
Okay. Seeing no more questions, our next speaker is Karen Susi. Ms. Susi, you're all set to speak.
Good morning, Madam Chair and members of the committee. It's nice to see everyone. My name is Karen Susi, and I'm testifying in opposition to House Bill 1247 as amended on behalf of the New Hampshire Manufactured Housing Association. The New Hampshire Manufactured Housing Association is comprised of manufactured housing park owners, private park owners, retailers, installers, lenders. We consider this broad sweeping legislation that assumes all non-payment of rent is related to the effects of COVID. This proposes a 6-month statewide rent control following the end of the state of emergency. Currently, landlords cannot evict due to non-payment of rent, and now this amendment proposes statewide rent control for 6 months. This also proposes a moratorium on filing evictions during the state of emergency. The eviction moratorium already exists in the governor's orders, so it is unclear to us why we are legislating this issue. Rather than a moratorium, perhaps there should be an effort to compel the courts to prioritize landlord-tenant actions. Allow the court to consider the effects of COVID on a tenant's ability to pay rent and reach deferred rental payment orders for a period of time. The eviction process has been a helpful tool that brings tenants to the table in order to reach an agreement to get things back on track. If not the courts, why not provide a form of relief in rental assistance? This would support tenants without crippling landlords. This legislation places the burden of solving the housing issues solely on the shoulders of landlords without considering their expenses and obligations. How do landlords continue to pay property taxes, mortgage arrearages, insurance, payroll, and other operating costs arising from the same period of time without receiving rent payments? Rent increases and evictions are issues that need to be handled on a case-by-case basis. This is heavy-handed legislation that clearly favors all tenants who are not paying rent, not just those impacted by COVID. While we are sympathetic to the impact of COVID on all New Hampshire residents, we respectfully suggest thoughtful solutions be developed in order to resolve the problem and not kick the can down the road. Passage of this legislation will perpetuate a problem that needs to be dealt with sooner rather than later. I thank you for your time.
Okay. I do not see any questions here, Senator Hennessy, so I will continue on.
Thank you. Thank you,
Okay.
Ms. Susi.
Okay, we have 5 more speakers, and the next one is David Collins. Mr. Collins, you're all set to speak.
Mr. Collins, I think you need to unmute yourself on your end.
Okay.
Can you hear me now? Okay, sorry about that. Good morning by my clock, 3 minutes. I am David Collins. I'm here testifying on behalf of the Hampshire credit unions, respectfully in opposition to specifically Section 3 dealing with foreclosures and forbearance. I did submit to the committee written comments with some level of detail, so I will be very brief here. We did, like our friends at the banks, we did survey our members on this particular language, and the common theme coming back from all responses was a overriding concern that the proposed language would inhibit their ability to work with members and tailor solutions specifically to individual needs. We recognize that the current pandemic clearly has created financial challenges for some individuals and families, but we also recognize that both the state and federal regulators have been very active in issuing directives on foreclosure and forbearance. The New Hampshire Banking Department has, in our estimation, had a very hands-on approach to this set of issues, and we have worked very closely with all of them. Credit unions on their own have taken some very specific actions to help their members, including lower interest loans, deferment of loan payments, fees on early withdrawals, waiving overdraft fees, skip payment programs, and extension of due dates on collections. It's worth noting, since May 14th of this year, credit unions have extended payments and modified agreements on 366 individual loans amounting to some $64 million. In our estimation, there's a lot of things happening. There's a lot of things that we are doing. We are not standing still, doing nothing, but we, on the contrary, are being very active in working with our members. We do believe that the balance of the current regulatory scheme is working, and the association urges the committee at this point to avoid making changes. I'll stop there and be more than happy to try to respond to questions.
Senator French. There you go.
Thank you. Thank you, Madam Chair. Dave, I was just trying to get this right. Did you say you were in full support of this legislation, or were you against it?
We are in full opposition to this legislation.
Okay, glad to get it right. Thanks.
Mhm.
Okay. I do not see any other questions, Senator Hennessy. I will go on to the next speaker. That's okay with you?
Absolutely.
Okay. Our next speaker is Nick Norman. Okay, Mr. Norman, you should be able to speak now.
Yep, good. Can you hear me now?
Yes.
All right, awesome. Thank you so much for the time to speak with you again. My name is Nick Norman. I'm the Director of Legislative Affairs for the Landlord-Tenant Law Legislative Initiative and the Government Affairs Chair for the Apartment Association of New Hampshire. We send out weekly updates throughout the state. We're in communication with about 4,000 landlords throughout the entire state or more. So the answers that I bring to you are a composite of responses from landlords across the entire state. This morning, in the earlier testimony, I said I sent to you some written testimony and email. Please pick that up and read through it. There's many, many points in there. Things are bolded, so it's an easy to scan through read of it. That document I sent you this morning talks about the original bill and the amendment. Right now, I'll talk about the amendment itself. Throughout the entire pandemic, there's been an overriding incredible imbalance of response to tenant versus landlord, essentially putting the burden of this pandemic on the landlords. And this amendment goes further in that direction. We have quite a number of landlords that are in touch with us that are letting us know that there are a great number of tenants that are abusing this system. They are receiving stimulus payments. They're not paying their rent. They're instead buying TVs and cars and just using as a free ride. At the end of this pandemic, when it's time for them to begin to start to pay up, most of those tenants, you'll find that they'll just leave, and then the cost of this entire time ends up being on the shoulders of the landlords with no recourse to the tenant, and the tenant is being held responsible. So overarching this entire process, that's a problem. We do need to see some rental assistance for tenants that helps them to pay the rent so that that money can go all down the chain of bill paying, like was earlier expressed by Matt Mending. And those rental payments need to be paid directly to landlords in the process similar to fuel assistance, something in that model. The process already exists. So let's talk about Section 2. There is a problem with welfare offices requiring demand for rents and notices to quit. However, that's not universal. We did our own little survey yesterday, and we found that The Concord Welfare Office never required demand for rents. The Manchester Welfare Office it doesn't require demand for rents and notice to quit. Other offices have. It's inconsistent throughout the state. So apparently that provision is not needed in the bill. Welfare offices already, some of them are not needing demand for rents notices to quit, and they certainly shouldn't be asking for them now because landlords can't give them. Section 3 talks about some mortgage forbearance. That's a good thing.
I'm sorry to interrupt, but.
Oh my goodness. There's so much more.
It
Please
happened
ask
quickly.
questions.
Okay. Senator Chanley, do you have a question?
I do, please. Thank you so much. And thank you, Mr. Norman. You mentioned that people aren't using their stimulus checks to pay their rent or their mortgages, but that they're using it to buy TVs and whatnot. Is that something you determined or you got through the surveys you mentioned doing?
I'm hearing that through the people that are responding back to me, telling me what issues they are seeing. So these are coming from landlords who are having the issue with many different tenants. And it's not the tenants paying mortgages. You said mortgages, so it's tenants not paying rent.
Yeah.
It's more common than you think. I'm sure of it.
So, but you don't have evidence of that through you don't have any evidence for that as beyond the
Some evidence, yes. Some landlords are able to provide evidence. Many times it's what's happened in conversation. The tenant is saying, yeah, I received my unemployment compensation. I'm getting my extra $600, but I'm not paying any rent to you because you can't do anything about it.
Thank you.
Okay. Senator LaVake.
Thank you. Thank you, Mr. Norman. So the renters that say they're not going to pay you, they still owe you the money, correct? They will be paying you at some point.
I would love to clarify this myth. So yes, they still owe the money. Will they pay it? Probably never, because they will leave, and the small claims process to chase after and secure a payment from someone, a previous tenant, is almost useless. That's a problem way beyond this legislation that we need to deal with in New Hampshire. A tenant that owes rent leaves, you can't necessarily find them. Maybe they don't have the ability to pay. Most of the time you can't find them. They just skip out on that debt. And there's thousands and thousands of dollars that are owed to landlords that will never, ever be recovered from this pandemic.
Thank you.
If I might, Madam Chair.
Yes.
I forgive me if I didn't ask this before of you, Mr. Norman. I'm thinking, how have your rent collection been through the pandemic? Do you have a sense of how many people are in arrears in terms of a percentage?
I do. So from what I hear from the people that respond to me and from my own records, we are practically twice the amount of money owed than normal. And many landlords are reporting something in the range of maybe 10 to 25% of the rents not being paid. But the bigger issue that hides the bigger issue. The bigger issue is that many of these landlords have not been paid rent since February. It's not the number of people that are behind, it's now the months that are behind. Some people are now 5 months behind, and in a normal eviction process, they would only go 2 months behind.
Okay. There are no more questions, so we will go to our next speaker. That is Patricia Murphy. Okay. Okay, Ms. Murphy, you should be able to speak now.
Good afternoon, Madam Chair and members of the committee. I hope you can hear me.
Yes.
All right, just for the record, again, my name is Patricia Murphy. I'm the president of the New Hampshire Local Welfare Administration Association and also the Welfare Administrator for the town of Merrimack. I did email a written letter of support for this amendment. And first of all, we thank Senator Feltes for this amendment. Since local welfare assists housing costs, this amendment supports tenants, landlords, and homeowners during this state of emergency. I would like to focus directly on the part of the amendment that affects local welfare. We are concerned about the shall not require language that suggests the documentation of eviction notice has no merit for the applicant under local welfare. Even though I agree that an eviction notice should not be required to get rent assistance, there are times that applicants are not eligible under non-emergency assistance. Eviction notice is required to document emergencies. This has allowed local welfare to do the following. It allows us to consider the applicant for a one-time emergency current rent assistance to prevent an emergency eviction. It allows us to prioritize their appointment and make timely decision. It also allows us to refer to other agencies which do require an eviction notice for rent arrearages. Strictly not allowing the documentation of eviction notice would unintentionally hurt the applicant by not allowing us to document the emergency. I would like to offer an additional sentence amendment to section 2 of the amendment. I did email this amendment sentence recommendation in the written testimony, and this is what I actually put in there as the additional sentence. An eviction notice may be required to assist the applicant in documenting emergency needs for emergency assistance, timely appointment and decision-making, and referrals to other agencies. By allowing this additional amendment to the amendment in this section under section 2 for local welfare, this will allow us to be able to do more for the applicants. And I'm just going to focus on that for now. And if you have any questions, I'll be happy to answer it for them.
Thank you.
I see no questions at this time. Thank you. And we will now have our last speaker on this amendment is Chris Norwood. Mr. Norwood, you should be able to speak now.
Hello, can everyone hear me?
Yes.
Thank you, Madam Chair, members of the committee for allowing me to testify. Much has been said already, so let me just jump to my conclusion. Well, first, my name is Chris Norwood. I am the 2020 Public Policy Chair for the New Hampshire Association of Realtors. I am also a small business owner and a commercial real estate broker with NAI Norwood Group in offices in Bedford and in Portsmouth. So my conclusion is that we are in opposition to the amendment as well as the underlying bill. What we really want to look forward to is, as Mr. Mending said, the House Bill 1129, which we believe appropriates $50 million through the CARES Act for housing assistance. And so that's kind of the conclusion. But just to get into some of the specifics on the bill, much has been talked about as far as the statistics on the unemployment benefits. One of the things that I should mention is we do not have any specific data. I believe Mr. Norman talked about some survey data on non-payments of rent. Nationally, the National Multifamily Housing Council reported in their survey 93% of tenants paid all or partial rent in the month of May. So that's the only national statistics that I can offer up to the committee. So specifics to the portions of the bill. On the payback portion, this is for if there has been arrearages, controlling how a landlord and a tenant reach an agreement on paying back those arrearages. No one knows exactly how many tenants did or did not pay all or a portion of their rent. We believe that a significant majority of tenants have paid their rent on time based on some of those statistics and some of the anecdotal stories that we've discussed. Many more landlords have worked out agreements with their tenants. We're actually seeing some property managers and landlords proactively reducing rents of tenants in this pandemic. So long as the tenants pay on time, it's kind of a positive incentive system. And we're seeing that that's working quite well to maintain rents outside of the need of this legislation. As it relates to the rental freezes, we believe that putting in any form of a rent control measure for the 6 months is just simply not necessary. As I mentioned before, some rents are actually stabilizing and declining as landlords do not want to lose their potential rental stream. Landlords are not incentivized in this market to increase rents. However, the bill does call for rent increases pro rata share for utilities and for operating expenses such as taxation, but there might be capital expenditures that landlords have put forth. I've talked with one land.
I'm so sorry to interrupt, but the 3 minutes is up.
Okay, thank you very much. I'll entertain any questions.
Okay. I do not see any questions, Senator Hennessy.
Okay.
That was our last speaker. If anybody that did not sign up or registered and I did not call on them, if they would like to virtually raise their hand right now, I can call on them. I do not see any hands raised, Senator.
Okay, thank you. So my understanding is that the next step is that we will unmute everyone and I will entertain a motion for going into. Yes.
Sorry, Senator, we just got to close the hearing first.
Oh, I'm sorry. I keep missing that. So we will close the hearing right now on Amendment 1363S. And I will look for a motion to go into executive session, which we will vote on by roll call. So moved by Senator LeVake, seconded by Senator Chanley. And we will need to do a roll call. So I'll go through the roll. Senator Chanley?
Yes.
Senator LeVake?
Yes.
Senator Carson? Is Senator Carson still with us?
Sorry, I was muted. Yes.
And Senator French?
Yes.
Okay, so we are in executive session. What I'm looking for now is a motion on House Bill 1162. It was the first one that we talked about.
Okay, Madam Chair, I'll make the motion. We're talking about the amendment, so I will make the motion of to pass on the amendment.
I believe we're talking about the bill first. Is that correct? Yes. So we're talking right now.
So the process that we have currently in front of us is we do need a motion on the bill itself in order to bring forward the amendment, and then we have multiple amendments on the floor currently. I believe 1384 was Senator Hennessy's amendment, and then if there's a decision to move forward with Senator Morgan's amendment to Senate Bill 549, we would need to make a committee amendment that includes that language.
So Jenny, let me understand this. So we're going to make a motion on the bill, then we're going to make motions on the amendments, and then are we going to go back and do another motion on the bill as amended?
So we'll have a motion on the bill and then not take a vote on that motion, just opening the bill up. I know generally that's not something we've always done in judiciary, but it's the process that a lot of the committees have been doing. And so just for consistency's sake, we'll just have the motion on the bill just to open up discussion for the amendment. And then we'll vote on the amendment and then vote on that original motion on the bill.
Okay, all right. So I will make a motion of what to pass.
on House Bill 1162. Thank you. So it was
Yes.
moved by Senator Carson. Is there a second?
Second.
Seconded by Senator French. So the next thing we will do is look for a motion on the amendment that combines, as I understand it, that combines Amendment 1396 and Senator Morgan's amendment.
I will move the original amendment, 1162, and the amendment was number 1396. That's correct. I'll move that amendment. And you need you need somebody to second that, correct?
Second.
So we need to, well, if we're, the intention of the committee is to include that amendment 1396 and Senator Morgan's amendment, we would need a motion on a committee amendment that would include 1396 and the language suggested by Senator Morgan.
I will move a committee amendment that includes 1396 and Senator Morgan's language.
And I will second.
Thank you. So moved by Senator Chanley and seconded by Senator LeVake. So we will then vote, have a discussion on the motion for a committee amendment that combines 1396 and Senator Morgan's amendment. Is there any discussion?
It's good with me.
Seeing none, unless you see anything, Trish, that I don't, Trisha? Nope. So I would like to have a roll call vote on this motion of the committee amendment that combines 1396 and Senator Morgan's amendment, which of course will be, and the motion is ought to pass. The roll call can be taken at this point, and I'd like to call first on Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
And Senator French.
Yes.
Okay, so, and I will.
Senator Hennessy, you also have to vote.
Yeah, I just said it, sorry, right. Senator Hennessy votes yes. And so the committee amendment that combines 1396 and Senator Morgan's amendment is, has been passed unanimously in the committee. I would like to ask Senator Carson if she'd be willing to take it out.
So Senator, sorry,
Yep, that's fine.
We need to vote on the bill now itself overall
I'm sorry.
on a not to pass as amended language.
Okay, right, of course. So we also now need to vote on the bill itself.
So Senator Carson made the original motion on that and Senator French seconded.
Great. So we'll do a roll call on not to pass for House Bill 1162. And Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
And Senator French.
Yes.
And I vote yes as well. So the vote is 5-0 on House Bill 1162, the amendment. And again, if Senator Carson is willing, I'd love to have her take it out.
Yep, that's fine.
Thank you. Now, I would like to recommend that we not vote today on House Bill 1247 and that we do so, I'm sorry, House Bill 1247 and the amendment. I guess we could vote on the House Bill, but I'd like to postpone voting on the House Bill and the amendment until Friday, because it seems clear to me that we need to do some work amending that amendment. So if there is no objection, I'd like to postpone that vote until we are meeting again on Friday.
I have no objection, Madam Chair.
Thank you. So in that case, I will entertain a motion to come out of executive session.
So moved.
So moved.
Thank you. Moved by Senator Chanley, seconded by Senator Carson. And I will now have a roll call vote on that. Senator Chanley,
Yes.
Senator LeVig,
Yes.
Senator Carson,
Yes.
and Senator Frank.
Yes.
And I vote yes as well. So we unanimously agree that we will come out of executive function. And I believe Senator Carson, that means you have about 20 minutes maybe at max to get ready for your next Zoom call.
Yeah. Yeah,
So
that's okay. That's been my life for the past couple, months, even with the task force, and Senator Chanley can attest to that. So it's all good.
It's all good.
Okay.
I'd like to thank everybody very much for your attendance, and I will look forward to seeing you on Friday afternoon.
Okay. Thank you very much, Madam Chair.
You're welcome. Thank you
Bye.
all. Bye-bye.
That's a wrap.
That's a wrap.
Bye.